Good morning. I am convening the Labor and Public Employees Committee meeting this Thursday, March 21st at 10 a.m. My name is Senator Julie Kushner, and I do want to announce that we will be in recess until 11 a.m. Okay, I think we are ready to reconvene this meeting of the Labor and Public Employees Committee. I'm Senator Kushner, and I am looking forward to getting through this agenda today and appreciate all the hard work that's gone into it. And we'll talk more about that later on. But for now, let's get started. And my co-chair agrees we should get started. Any comments from ranking members?
Thanks.
Okay, great. So we will go to item number 1 on the agenda, and Senate Bill number 7, an act concerning Connecticut paid sick days. It's a JFS to the floor, LCO number 3333.
So moved.
Second.
It was moved by Representative Hughes and seconded by Representative Wilson. I couldn't tell who said that. And I do want to suggest that there are 3 bills on our agenda today that address Connecticut paid sick days, a Senate bill, a House bill, and a governor's bill. And I'm going to describe them, all 3 of them, briefly so that we can have a discussion about all 3 bills as part of our process. Of course, when it comes to voting, we will vote separately. These bills all are very, very similar. I will start by saying that there is S language, and the S language is all the same. The S language is a result of the public hearing that we had. When we heard from the public, we all agreed, the Senate, the House, and the governor, that we should adopt the language from the paid family medical leave statute to address the definition of family for paid sick days. And so that is the entirety of the S language. It is about having the same definition of family that recognizes family relationships in the same way. It will, in the same way that we do paid sick days, will follow what we have done in the Paid Family Medical Leave Act. These bills all provide for employers in the private sector to provide employees with 40 hours of paid sick leave annually. The difference between the Senate bill and the governor's bill are essentially the same. The difference with the House bill is in twofold. The effective date for the Senate and the governor's bill is October 1st, 2024, at which time all private employers would be subject to the legislation. In the House bill, the date is January 1st, 2025. The House bill contains a phase-in of employer size to be covered by this legislation, as opposed to the governor's bill, and the Senate bill would have all employers effective immediately. There is additionally, in the Senate bill and the governor's bill, there is the accrual for employees is based on 30 hours. For every 30 hours worked, you would earn 1 hour of paid sick leave. In the House bill, there's a variation on that would provide for an automatic contribution or an automatic entitlement to paid sick days at the beginning of each year, the same amount of time, but you would be able to use it at the beginning of each year. For new employees, the governor's bill and the Senate bill say that an employee would have worked for 100 calendar days in order to be eligible for the accrual that they had earned. In the House bill, a new employee would have to work 180 days in order to qualify for their full entitlement at that time. On the 181st day, they would be entitled to the 40 hours. So those are the distinctions between the House bill and the Senate and governor's bill. But in essence, they all would. And I think the other thing that is really important to note, in the House bill, there is a phase-in of employers. And that would be starting on January 1st. In 2025, employers with 25 or more employees would be covered by the bill. On January 1st, 2026, employers with 11 or more employees would be covered by the law. And on January 1st, 2027, employers of all employees would be covered by the law. So those are the distinctions. I hope I kept it clear enough for you all. It's item number 1 has been moved and seconded, so I would ask for any comments or questions. Representative Weir.
Thank you, Madam Chair, and thank you for the explanation on those bills. Between the three of them, they're what I counted as 14 pages each. So that's 42 pages of 42 pages of language that, for the most part, say a lot of the same things, but it's a lot to unpack. So I think we'll be spending a little bit of time. I would like to spend time today talking about, primarily Senate Bill 7, making any distinctions as we go along. But some of the concerns that I have with this bill, and I'll ask some statements, or some questions, but I'll begin with a statement. And I think that inside this building and inside our government, we often make assumptions that if we have an initiative we want to pass forward, we want to push forward because there's some advocacy or somebody or a group pushing for it. If it falls on the backs of businesses, and often we try to make a distinction by carving out and splitting up and maybe driving a wedge between the small businesses and the large businesses. And there's an assumption in this building, I perceive, that if we want something, we will we want a certain initiative to move forward. We're just going to push it through, and that the businesses are going to figure it out. And that's going to be up to them to figure it out. They're going to have to figure it out. It's not our problem. We're going to pass it because we've had again, people requesting it, and the businesses will have to just figure it out. And the problem with that is that at some point, and that point I would argue has happened a long time ago, you get a reputation for being an unfriendly state to business. And the vast majority of revenue, wealth, commerce that exists, not the vast majority, it all happens in the private sector. Government provides adds nothing to our the products that we produce. It produces nothing. So when we're talking about creating these regulations, we're passing these along solely to private industry, and we're affecting, as we've talked about on many different occasions this session, different bills, different committees, that we affect that relationship between the employer and the employee. We assume that the two of them have to be at odds, and that labor and management can't work it out amongst themselves. So we must get involved. And at the end of the day, it's the wrong decision. So I do make that, I'll end with that statement. I would like to just ask some questions, go into some specifics, and start on page 2. So again, we're looking Senate Bill 7, LCO 3333, just to make sure we're reading from the correct document. Line 40 to 45 just caught my eye. Lines 40 to 45, I should say. It talks about an employer and what does not constitute an employer. So I got hung up on an employer that participates in a multi-employer health plan in which more than one employer is required to contribute to such a plan, and such a plan is maintained pursuant to one or more collective bargaining agreements between a construction-related trade person, employee organization, or organizations or employers. I'm reading that group is excluded. I'm trying to figure out what is a multi-employer health plan, and I guess appreciate if you could let me know what that means.
Certainly, under federal law, there are provisions for multi-employer trust funds to deal with health and welfare funds that are typically found in union organized workers. In this case, this is specific to the construction trades, although multi-employer trust funds can exist in any type of workplace. But this is specific to the construction trades specifically.
Okay, so these people are excluded. This group or this group of employers is excluded if they're part of a multi-employer health plan or wellness plan.
If they're subject to a multi-employer health plan that is maintained pursuant to a collective bargaining agreement between a construction-related trade organization and the employers.
Okay, thank you. So is it assumed or is it required then that that type of health plan would meet or exceed the requirements that we're planning to, that this bill would look to put on employers less than 50?
It is understood that those employee-employer relationships are very different than most, if not all other relationships that are considered employer relationships under federal law, under state law. They're very different relationship in the way that they work. So the collective bargaining agreements have taken that into account, and as such have provided different ways for persons to accrue benefits.
Okay, thank you for that explanation. Same page, I would like to jump down to lines 46 through 49, where it talks about the family member. You talked earlier, you mentioned that the language in this bill reflects kind of being married up with or more consistent with the paid family medical leave. Family member means a spouse, sibling, child, grandparent, grandchild, or parent of an employee or an individual related to the employee by blood, which, I completely understand that. But then it says, or affinity, whose close association the employee shows to be equivalent to those family relationships. Could that be a neighbor or a roommate or, a close family friend or how far does that stretch, that where we talk about an affinity where the association, where the employee shows that to be equivalent of a family relationship?
I think what is intended and clear there is that there doesn't have to be any blood relationship. So it could be any person who stood in the relationship akin to being a parent or a sibling or a spouse, a grandparent. So there would have to be an ability to demonstrate that close association.
Okay, and I recognize that under the paid family medical leave statutes, the definition is perhaps more loose because it's theoretically the employee is the one paying into that fund. But here we're asking employers to pay into, they're going to be responsible for paying, taking on the entire burden of granting, providing these benefits for the employee at, based on our direction up here at the Capitol. So since we're putting that burden on the employer, who gets to make that that determination, and how is affinity defined? If the employee comes in and says, look, I'm very close with my neighbor and I need to take care of my neighbor, who makes that determination? Whether that's a valid claim?
If the employer refuses to grant the time and the employee felt that they could demonstrate the close association that would meet the requirements of the statute, they would obviously have an opportunity to say the employer has violated a law that we have passed here and pursue all the remedies for enforcement that exist throughout the statute and with any of same as any of our other laws.
So who is the first, I guess, what's the first step in that process where if the employee feels that if the employer denies the time because the employee says, my neighbor or I hang out at the gym and the person behind the desk is like a family member to me. And I want to be there for them in this time of need. If the employer doesn't agree, doesn't grant the time, what's the first step in that cycle? Or what are the next couple of steps as to how the employee can get can close that, how can it be determined that the employee is correct?
Hold on one second. Let's take a brief pause. If an employee felt they had been wrongly denied access to the sick leave, they would have to go to the Department of Labor for a violation of wage and hours, like any other wage and hour claim. DOL would make a determination if they ordered the employer to pay those benefits to adhere to the law. In that case, and the employer chose not to and defied DOL, then it would go into court.
So is it possible then that DOL could side with the employer and say that this doesn't meet it doesn't meet the equivalent of a family relationship, regardless of the employee's feeling that there is an affinity there?
Yes.
Okay, so I do have concern where we started here, that isn't clearly defined, and you've left it up, or I don't say we, somebody else who, whoever wrote this bill, left this vague where, you've left it, it's a subjective matter where the employee, feels that this meets the equivalent of a family relationship. And we've also left it subjective for the employer to determine that. And now if that ends, the two of them have a disagreement on what affinity means and association, what equals a close family relationship. Now we have the employer saying no, the employee saying, yes, I believe it is. It goes to the DOL, and there are, going down the line, there were fines involved, and so I'm concerned that that we haven't defined that. And I think we're putting both sides in jeopardy by doing this, although it doesn't seem like there's any, all I see is fines for the employer. I don't see any penalties for the employee through this. So, but I'll leave that as a concern. I think that we should address that if this moves forward. Okay, page 3, we're on lines 60 through 63. And it looks like that's the new subsection 8. So it talks about the reasons that an employee can take, this is in the reasons that an employee, well, I guess it's a definition. Mental health wellness day, in quotations, means a day during which an employee attends to such employee's emotional and psychological well-being in lieu of attending a regularly defined shift. So again, I don't see a definition. I mean, I see a definition for a mental health wellness day, but who determines psychological well-being of the employee?
This language is currently in statute. It's the only change to the language was to change from the previous limitation on who was covered by the act. So it would be expanded to include all employees. So it would be the same process as currently exists under statute, and it would be DOL.
Just for clarification, that exists today under our current paid sick leave, which is 50 employees or more. And we're going to take that down to 1 employee.
Correct.
Okay. All right, I think if I skip to page 6, lines 152 and 153. Um, it looks like that's existing language, but I just want to be clear. Again, because we are opening this up um, to everybody. We're not, I think it was onerous enough with 50 employees or more. Now, we're talking one employee or more. As I read this, employees can carry over 40 hours, unearned hours. They can carry that forward into the next year. Is that correct?
That's correct.
Okay. So they can carry this over. Okay, then I will move down, that puts that aside. I'd like to move down to line 170, because this is new language. 170, 171 talks about, employee is entitled to use the accrued paid sick leave, and it gives some dates. And it says, of course, we've got a service worker still in there. So they talk about when they can use this time, as I'm reading this correctly. So lines 170 and 171 says on and after the 100th day of such employee's employment. I didn't see it spelled out. Is that calendar days or working days?
So just to be clear, you, in reading this, it's lines 161 and 162. Everything after the word sick leave is eliminated until line 170 and 171. So I'll read the whole sentence. An employee shall be entitled to the use of any accrued paid sick leave on or after the 100th day of such employee's employment. And that is calendar days.
Okay, so then I think the question still, I still have the same question. Is it 100 calendar days or working days?
Calendar days.
Calendar days. So how was that number? How did we come up with 100 calendar days? Is that the math of 40 hours a week times the hours that can be accrued per week to get to, because I know we're trying to get to 40 hours. I'm just trying to do the math real quick.
There isn't any math involved at
Oh.
all. It was much more about looking at the way most employers conduct business, and that a new employee, this applies to a new employee. And in most cases, it's very common for employers to have a probationary period. And this exceeds what is most typical, which is 3 months, which is usually 90 days. But it was an agreement we reached last year as a compromise to what had been earlier proposed by the Senate, and looked at that being a sufficient amount of time for an employer to evaluate whether an employee should continue.
So we talk about the employee can carry that over. What happens if the employee doesn't? What happens to the unused sick time? If the employee can carry over 40 hours, as I understand it, from at least my own previous experience, 40 hours carried over into the next year, you could potentially have 80 hours, but you can't continue to, I don't think you can continue to, no, there's a maximum. What happens once you've reached that cap and the sick time is unused? What happens to that sick time?
So under this proposed legislation, an employee can carry over unused time from year to year, but they can never use more than 40 hours in a given year. So it is not a case that you might see in other employment situations where people are banking sick days and have a pot of sick days to use if they get seriously ill, or some employers will allow a payout at the end. Nothing in this legislation requires banking as such. What it would provide for is that if an employee has not yet started, if you're an ongoing employee, you have unused sick time, you carry it over to the following year. say you get sick the first month of the following year where you've begun to accrue again, you would have an entitlement from the previous year to use. But it does not ever allow you under this legislation to use more than 40 hours in a year. Is that clear? So what I'm saying is that if you're an incumbent employee, you've accrued sick time that you didn't use, you can carry over that sick time to the next year. Should you get sick before you've earned your new 40 hours of sick time, you could use the time from the previous year. But anytime once you reach the 40 hours, if you do it in January because you hadn't used sick time the year before, you've used your allotment. The employer's not required to give you additional days, even though you're earning them. This only requires an employer to give you 40 hours in a given year of paid sick time. Certainly, many employers exceed that and have different policies, but this is the minimum requirement.
Okay, so just theoretically, if 2024, I should probably just make this 2025.
Okay.
Start off with 2025. The employee earns 40 hours or is granted, because I don't think this is earned because the state's mandating that the employer provide this. It's provided, not earned. 2025, they're provided 40 hours and they don't use it. The employee doesn't get sick. That 40 hours carries over to 2026. And I had to write this out just while we're talking.
Mhm.
They don't get sick again and they have another 40. So that's a total of 80. We go into 2027, they get another 40 if they don't get sick. So they could conceivably, is it my understanding, they could conceivably have 120 hours after 3 years? And if they don't use it, but they can only use 40 of that 120?
It's really irrelevant because you can only carry over your 40 hours from the year before, and you can only use 40 hours in a given year. So an employer doesn't have to bank that time. They simply have to allow someone who didn't use the sick leave the previous year, they have to allow them up to 40 hours, even if it's the beginning of the year and haven't yet accrued their sick time.
And I don't mean to belabor this, but I want to be clear. So you have 40 that were carried over from year 1 to year 2 that they didn't use. They have the option to use that right away if they got sick. And they're still accruing. So, but they can only use 40 in that year. So are they always behind, or is it possible that they could use up to 80 in 1 year?
They can never use more than 40 in 1 year.
Thank you. Now I'm clear on that. And the employer doesn't have to pay them back, doesn't have to pay them for any unused time at any point in the paycheck after the fact.
There's no requirement in this bill for any unpaid payout of unused sick time.
Okay. All right. Thank you for that. Go down to page 7, lines 201 through 205. Which appears to be new language, F subsection 1. If an employee is transferred by an employer to another division, entity, or work site, but remains employed by such employer, such employee shall retain and may use all paid sick leave accrued or received by the employee while working at such prior division, entity, or work site. So could the what would happen if the employee were transferred out of state? If you have, you got a I'm not sure the example, I don't want to use a company name, but you have a company that does business in multiple states, under 50 employees. If the employee were transferred out of state, would they be entitled to, I mean, I imagine it would be willing if they're going to be moving out of state. Or maybe they shift their operations and there's nothing more going on in Connecticut and they're moving to New Hampshire. Would the employee be entitled to any benefits if they're transferred out of state?
Hold on 1 second. We're gonna, I will answer the question, and then we're gonna take a brief recess to go vote in appropriations. But the answer is that we cannot enforce our laws in other states. And in fact, this is specific to people employed in the state of Connecticut. And we will take a brief recess. We're going to go back on the record. It turns out they're not ready for us to vote yet. So um, it's a big committee, you know, so. Okay, I'm sorry, Representative Weir. I know that it's a little hard to keep your train of thought when we do that. I apologize.
Quite all right. I have took copious notes. I'm ready,
Okay.
ready to go where I left off. So if we flip the page to page 8, lines 211 through 214, it talks about no employer shall require an employee who will use or is using paid sick leave to search for or to find another employee to serve as a replacement for such employee to work the hours that such employee is or was scheduled to work. So can the employee offer to find someone to fill their slot if through this?
The language of the statute is clear. It can't be required by an employer. It does not address whether or not someone voluntarily can take that action.
And I just want to make sure that we're clear, and nothing in this law prohibits an employer from asking, not requiring the employee to find a replacement.
I think that it is clear in the statute that they can't require it. I think it would be left to DOL if an employee felt that the request was a requirement. And so someone could potentially say, well, they asked me to do it, but I didn't have a choice. And so I had to, or I forfeited the day. I think it's unlikely to happen. But, you know, I think strictly speaking, if we look at the words of the statute, it says they can't require. And it would be up to DOL to determine whether or not it was an ask or a request or a requirement.
Okay, and the reason I bring that up is that in my history, a lot of the work that we've done has been on call or emergency based, and people do get sick, things come up, and we, as an employer, we were always trying to be flexible because maintaining a happy and an appreciated workforce was very important to us. But in that sense, if somebody had to call out for any number of reasons, it was not uncommon for them to either offer, because they were working in close proximity with peers who they knew each other's schedules, or they knew, hey, I got a family thing this weekend, but so-and-so is around and can cover for me. There were times that we asked, somebody would ask to call out, and we would ask, can you think of anybody who could fill, with that type of same skill set to fill the position during that period of time. So there was that free exchange of information, an offer, an ask, and I want to make sure that we're not prohibiting that through this law. Sounds like you answered my question, but I want to make that clear, the reason for asking.
Sure.
Back, same on page 8, lines 238 through 240. We talked about sick, this bill talks about paid sick leave, but this paragraph, I don't see, I'll just read it and then have you correct me if I'm not reading this correctly, but one of the reasons that an employee can request sick leave is foreclosure by order of a public official due to a public health emergency of either an employer's place of business or a family member's place of business or care. And to me, this doesn't sound like sick leave. So I'm just trying to figure out how, if by order of the public official. that, that this paragraph would fall into the language.
I believe it's there for a very important reason that we want to be clear in the legislation that if an employer's business is required to be closed because of a public health emergency, that the employee can use those days that they have accrued. Clearly, this is relevant today because of the pandemic, where employers were required by government order to close. And in other cases, clearly, schools closed during the pandemic. And during that time, parents needed to stay home with their kids. And so we want to be very explicit in the legislation that that could be a reason that an employer would have to allow an employee to use those paid days, paid hours, I should say.
Okay, thank you. I'm going to just go over to page 9 and starting with lines 264. Talks about line 265, that an employer may require reasonable documentation. And then on line, in that paragraph, it talks about, I guess, what could be reasonable documentation. But I didn't see any requirement for a doctor note, which I've seen, used before when you're taking consecutive days off, that, 1 day, fine, 2 days. But if you're going to be out for an extended period of time, having some sort of a doctor's note is helpful to verify. And I didn't see that in here. Is there a reason why the doctor's note was left out of there, where you could have the evidence from a professional who would validate that this employee is ill, and having it backed up by a professional?
This is existing statute. This is the requirement that exists currently in our paid sick days law. And I can tell you, I believe it's existing statute. I'm sorry, what do you?
I'm looking further down, if you get into lines 273, the employee, that's new.
Oh, okay.
And it talks about the statement from the employee affirming, I was going to get there, but, so a written statement from the employee affirming that such employee is using or has used paid sick leave for the purpose of said subdivision shall be considered reasonable. I understand that, I suppose if somebody has a rough night, or they're, ill one day, they're going to call out, but it's been, I've seen it used in practice where after several days, I don't want to, I'll just say 3, but maybe it's 5, after multiple days, that it's customary and reasonable to ask for a doctor's note. And nowhere in here that I see in the new language, does it talk about having a professional validate that this employee is indeed sick.
So again, I don't think that there was a specific doctor's note requirement previously. I think this goes further to explain what a reasonable documentation would be, and clarifies that there are ways to produce documentation. Just want to be clear that the bill, you can't accrue more than 40 hours. So we're not talking about a situation where somebody's out for more than 5 days. Someone could be out for more than 3 days, obviously. But I think that what we are recognizing in doing this, speaking to the issue, it is really very difficult and costly for many people to go to the doctor when they are home sick with a cold or the flu. It is not uncommon to, stay out for a period of week if you have a very bad cold or very bad flu. Going to the doctor can be cumbersome on people coming up with the money to pay for that visit to the doctor. So I think that we were sensitive to that. And we don't believe that, we put in some language about a written statement affirming it. But I think that the understanding is that we're not requiring a professional, as you said.
Okay, thank you for that. So to that point, if the employee issues a written statement that affirming that they're using it for paid sick leave. And let's just say that that employee took a couple days and went out, went on vacation. If the employee lies, are there any penalties? What are the ramifications for the employee if they issue a statement affirming that they were using this for sick leave and instead they're, using it for something that this wasn't intended for?
Uh, in most circumstances, obviously where there's a collective bargaining agreement, there are usually grievance procedures, but absent a collective bargaining agreement, an employee at will, an employer can discharge an employee for lying, whether or not that, the employee would have remedies, limited remedies under the law, but they do have some remedies they could seek if they believed they were unjustly terminated.
Some of this I'm quite familiar as an employer and an employee, working within a handbook and knowing what the rules are. But here, in this case, we have the state of Connecticut creating rules to be, you know, put on both parties really. And so I want to make sure that this is clear language when we're creating a burden on the employer. Um, that's the reason I'm asking these questions. This isn't something that's voluntary. This is not, between the employees and the employer. We're getting involved in the middle, creating, benefits where they didn't exist before. So, um, skip that.
I just do want to make one point. The section that you've been discussing here references when there's been a closure. When there's a closure by a public official, there's no requirement for that documentation. But let's look at lines 267 through 268.
Which is existing, correct?
That is existing and it wasn't taken out, that for paid sick leave, 3 or more consecutive days, an employer may require reasonable documentation signed by a healthcare provider. I just want to be
Okay, I see
clear
that
that
now.
there are
Thank
two
you.
different instances in which one where you would not be required, but one where you would.
Okay, so the 3 or more days, the reasonable documentation and reasonable documentation could include a doctor's note. Okay, I see that now. Thank you. Page 12, and again, out of 14 pages, we're getting to the end of my questions. So, page 12, lines 363, 364. I guess that's existing language now that I mention it, but can you just clarify that it's $100 for each violation, and is that by day or is that by the employee?
I'm sorry, would you repeat
Sorry.
the lines?
Lines 363 and 364 talks about a civil penalty from the Labor Department up to $100 for each violation. And I'm trying to figure out if that's is the violation considered each day or is it each occurrence? So, and is it each employee? Let's just say 3 employees called out sick and the employer didn't believe they were warranted. Is each employee considered a violation? Or is that one instance if 3 were denied?
Hold on one second. It's intended to be that if there are 3 separate cases, there would be 3 separate violations and each one would incur that fine. But there's no mention of a daily penalty.
All right, I think that's it for my questions. I do have some remarks to make uh, about this bill, and I'll be mindful that I know you have to go vote, so just feel free to let me know at any time. But I did a little bit of research as we're looking at this bill. Yeah, it was very concerning to me when we passed this bill some years ago, prior to me being here. And looking at the other states that provide some sort of mandatory sick leave, and there's 21 of them. So in that respect, Connecticut was not alone, although currently the way that it sits, Connecticut with today's benefits is one of the, at 50 or more employees, is one of the most generous in the country. And then I went looking for which states provide benefits down to one employee, and it was some of the usual suspects: California, Illinois, Minnesota, New Jersey, also New Mexico, Vermont, and Washington. So 7 other states provide pay this type of benefit that we're looking to go to. And one that was specifically not there was Oregon, which I was very surprised at, based on kind of how their policies go. But it's concerning that, when you look at some of the states that have some of the best economic conditions and environments for business, I don't look at those 7 states as well, they're not what I look at. They're not near the top of the list. Even though California has one of the biggest economies, it's not, economically, it's very regulatory heavy, regulation heavy, and we're heading that direction. So, I want to remind people that every action that we take up here has a reaction out in the real world. We assume, as I said before, that those businesses they'll just have to figure it out. The real world is, the reality of it is that when, people get sick, people have family emergencies, all of these things happen. And in the ideal world, the employer and the employee are going to work together to figure it out. And it may not be a paid sick day. It may be, geez, I'm sick, I can't work Tuesday. And they work it out, an arrangement where they'll swap Friday. Can you work Friday instead when you're feeling better? I can't pay you not to work, but I can, if you were going to have Friday off, you come in, and that's an opportunity for the employee and the employer to work it out and let the market work and let people be free to negotiate. I recognize that when an employee calls out of work for any reason, whether legitimate or not, it puts pressure on their fellow employees, the employer, customers, suppliers. Everybody can potentially be affected. And the smaller, maybe a company that has 500 employees, if somebody calls out, the impact may not be critical. If it's 50 employees, it may be a little more critical, unless it's maybe the person signing the paychecks on Friday. But you start pushing this down to 1 employee, 2 employees, where that may be the only person performing work outside of the owner of the business. This could have a huge impact on just the viability of a small business being able to survive. And if the employees are encouraged to do that, they're going to be provided this time with very little documentation as a result. I think this is going to have a negative impact on our business climate, business community. I've certainly heard from a lot of small businesses, many different types, that this would be extremely onerous, burdensome. A couple of them said, this would kill me. And what's, here's another regulation coming down the pike. So I have a recommendation. I think we should encourage more utilization of the paid family medical leave today, which is not fully utilized, rather than force another mandate on our small businesses. And by pushing this bill forward, we're not encouraging further usage of our paid family medical leave. We're actually discouraging it. So it's not fully utilized. And by the way, that burden is picked up by the employees at 0.5% of the pay. Here, we're going to say, we're going to discourage the use of that and push these costs onto the businesses, further discouraging our business community. So we heard a lot of testimony actually, I was surprised to see and pleasantly surprised to see business owners taking the time away from their jobs, from work to testify in opposition to this. Uh, Typically, it's been my observation that you have a lot of the organizations who will come, paid representatives who will come here, take the time. Uh, but the average working person is not taking the time. So I'm pleasantly surprised to see that involvement uh, in this process. I think it's so important that our citizens are involved and engaged in what goes on up here. Very happy to see that. So I think when we look at an overall business climate, you've got, why would a business want to come to Connecticut? Why would a business want to stay here? You want to look for where there's a place where there's a skilled workforce, where there's low operating costs, low taxes, low regulation, low energy costs. And other than the skilled workforce, we don't have low operating costs here. We certainly have a highly regulated environment. Our energy costs are second highest in the country. Regulation is high. And I guess modern infrastructure would be another one that would encourage somebody to come or stay here, but we don't have that either. So I think we really need to look at the policies that we're pushing forward. I think this bill and the other two bills that are mirror images of it need a real strong look. I recognize that one is a Senate bill, one's a House bill, and one's a governor bill. And I think all three of these bodies need to look at this language, look at what we're trying to achieve. If we want to make Connecticut more economically competitive, we want to encourage people to make it here, as is our motto, then we need to, then this bill shouldn't move forward. In no iteration should this move forward. And we should encourage small businesses, employees and employers to get together, to be free to negotiate the benefits and the terms of the employment agreements. So by taking the employer's ability away, the employer may say, look, I can't give you sick days, but I can give you can work alternative hours. Or I can't give you this other type of time off, but I can provide you more pay. And again, I don't know the specific example other than we shouldn't be interfering in that. I don't think anybody in this building knows better than the employer or the employee as to what's going to work best for both parties. You've got employee handbooks in the private sector, public sector. We all have a handbook that we can go back to, and that lays out the terms of employment and where the laws, what's legal, what's allowed, and then what are the benefits. We don't need a mandate to tell us that. So I'll just close with, I think, we've had discussions up here this session and last about crime, about electric vehicles and business and the business climate in general. And I think these policies are really out of touch with what's going on out in the real world on Main Street. And I would encourage this legislation not to move forward. Thank you.
Thank you, Representative Weir. We are going to take a recess for lunch now. We will reconvene at 12:45.
I don't know what you're gonna ask, and I don't know if Ken wants to speak on it. I have to get you over. Where's Ken?
Okay, we are going to reconvene this meeting of the Labor and Public Employees Committee.
So you could do, there's other bill. There's two more. These are all the questions though. Okay.
Representative Yacarino.
Thank you, Madam Chair. And, I listened to the good ranking member, Steve Ware did a terrific job in answering asking very important questions. But my question is something pretty simplistic is, my friend Joe, who died last year, would have been 96 or 97 now. He'd always say, ask the question why. Your last name begins with a Y, ask why. Why? So maybe it's a foolish question, but we have paid family medical leave. The funds are abundantly doing well. Program is going fairly well. Why would we be doing this when we have a program? Because paid family medical leave, and then you're getting the benefits for here for up to 40 hours, which is really one paid week a year to your employer paying it. Why are we having the employer pay it when people are paying into it currently? I know Representative Ware asked that, but I didn't really get a clear answer. Why would we change? Why do we be diverting from the program that's working? Because it's still going to be used to something that is mandated on a business. And my question.
So people who need to use sick days typically are for a case of flu or a cold or a safe day, and this bill is covered. But clearly, mental health day, those are not covered by the Paid Family Medical Leave Act. The Paid Family Medical Leave Act is restricted to illnesses that are considered serious, and you have to meet certain criteria for the bill, for the benefits to kick in. So many workers, most workers, we had this happen a lot. A lot of people applied for instance, they got COVID or they tested positive, they had no symptoms, but they had to stay home. They would not be covered under the Paid Family Medical Leave Act.
All right, I thought that's what it was, but I just wanted to hear, actually hear it. To me, it becomes obviously like we've heard another mandate, but most businesses, like my business, I would just change it. What if I change it where you're going to get one paid week off a year, 6 days, and one week of vacation time, and then 3 personal days? Would they be able to use those 5 sick days and 5 more days here or a week's time?
An employer who has paid time off policies, as long as an employee could use 40 of those hours, if they qualified for 40 hours, as long as they could use them for illness, for sickness, then that employer does not have to provide any additional benefits.
So currently, if I give, just to be clear, 5 sick days, a week's vacation time, and 3 personal days, plus all the major holidays, Labor Day, Christmas, Thanksgiving, 4th of July, Memorial Day. Well, Memorial Day, it's a Monday. I give all those now, and I give 5 sick days, and I give a week's vacation, and I give 3 personal days. Do I have to go above and beyond that? Because it doesn't say in here. I know people are shaking their heads, but I want to see that you don't have to add on that.
The law is clear, and it has absolutely been clear, and the intent has been made clear repeatedly, that as long as an employer provides up to 40 hours of time that a person can use for a sickness, then they are not required to provide any more time under this statute.
And so as long as it's statute. And then another question. So what's the criteria? 30 hours on this list currently?
For every 30 hours you work, you earn 1 hour of paid sick time.
But if you work 20 hours a week, do you still qualify?
If you work 20 hours a
specify.
week, then when you've worked
2 weeks?
1 week, you've worked 20 hours, you haven't yet accrued an hour.
So it does.
But the next week, if you work 20 hours, you will have accrued, you would have worked 40 hours, you would have accrued 1 hour.
So then you do qualify for this if you work 20 hours a week or 16 hours a week or 15 hours a week or 12 hours a week. You qualify, and you just multiply those numbers to get to the 1 week paid.
You qualify based on you qualify for hours based on how many hours you've worked.
I understand, last year was my first year on this committee, it's my second year now. And I understand we have difference of opinions and we all, I think, do care in one way or another. But I really believe that some of these policies, like if somebody's just, their business is just making it and they have to do things that they might do on their own, but now they're mandated. They might not give that person extra hours. They might not hire that fourth or fifth person. I'm looking for help right now because my manager left and I have a full-time employee and I have somebody that works part-time, but now she's been having some issues not coming in. And I'm looking to hire another person. I'm going to think now if this was the past going on the road, do I really want to put that 20 hours a week when I would pay that anyway, but I don't want to be mandated. And I think it's, again, we don't agree on this. I just think it becomes a burdensome policy, like many of the policies that are passing out of committee this year, and hopefully they don't become law, that eventually hurts the relationship between an employer and employee and potentially our state. So you could have an employee, one last question. Say you have an employee and there's issues and you found out that there were misgivings or stealing, but then all of a sudden they want to take 5 days off or 4 days off. What happens then? There's nothing in statute or language for that. Would that go to the Department of Labor? Would that go to some sort of arbitration? Because that could be, it's hopefully rare, but it could happen.
So I want to make sure I understand your question, but there is no provision, I can be clear that there's no provision for arbitration in this statute, in this proposed legislation. You're suggesting that if an employer found an employee guilty of stealing, would they get paid sick days?
Yes.
I believe it would depend on the action of the employer. If the employer fired them, then they would not get paid sick days.
But it doesn't say that.
Well, no, it's very clear. You have to be working in order to qualify for it. So if
But
you've been
but
fired, then you don't get paid sick days.
But the person could say, well, I was working, I was ready to take them off, then I got fired with no warrant, when there really was a warrant, then it's a litigation issue. I just think it's well intended, but I think there's a lot of flaws and I won't support it. But again, I said it the other day, I know you care. We totally don't agree. I think there's a lot of unintended consequences. And I think most employers, I do, and I think most do treat their employees really, really well, because you want that employee to be part of that business, that family, and you want to take care of them. And I can't get into other details, but there are times when you really bend over backwards for your employee. And I don't think that's recognized enough. I think there's so many policies or potential policies in this building that really make the employees the adversary, that they're the bad person. They're not treating people right. And at the end of the day, it's like what we do to our law enforcement. We constantly bring the hammer down on them, but then we want them when we need them. I just think it's just the same thing. We just totally don't agree. So thank you for your indulgence, Madam Chair and committee.
Thank you. Senator Sampson.
Thank you for the recognition, Madam Chairman. So we're discussing the 3 paid sick day bills that are on the agenda today. And I understand that there are 3 versions of the bill because there's some disagreement over what the final product might someday look like. Plus, I think there is a desire on behalf of the majority to have both a House and a Senate vehicle so that it could start in either chamber if necessary. And that's their prerogative. I prefer to keep things to one bill. Might make things simpler for us to actually use the committee process for what it's intended for, which is to actually debate and refine the language of the bills that we work on, instead of simply advancing multiple vehicles, which are very likely to morph into something else before we ever even vote on it on the floor. It kind of makes the process here extremely frustrating for someone serving in the minority, because I know I'm debating a bill that I may not even see. I've got to prepare for that. The last couple of agendas we've had in this committee have had substantial amounts of substitute language, which we get. And I can't believe I'm saying this, but I appreciate the fact that we're getting it the day before, but that's not good enough, really. And I don't think it's fair to the public, because that language is often not made public either. There are people right now watching this committee meeting, very interested in this debate, and they can't even look at the bill that we're going to be debating and voting on because there's a lot of substitute language out there. And that's not made public. So just to refresh people's minds who are watching or maybe catching this in the middle, what we're voting on is an expansion of Connecticut's paid sick days statute, which is a mandate on businesses that operate in Connecticut currently with 50 or more employees that they must provide a certain amount of paid sick time. And the bill that's before us makes, quite a few changes, but the most significant one, and I think the most onerous one, is to change the requirement from businesses that are 50 or more employees to businesses that have as little as one employee. My colleagues have already done a very good job of describing, the language of the bill and the impact that such a change might have on business and industry in our state. And I think that's clear to anyone who thinks about it for a second, that obviously, a large company that has numerous employees can certainly fill a gap a lot easier if someone is missing with little notice than a small employer who maybe has a small retail store that has one employee, and that one employee is supposed to be watching the shop. That obviously is going to have a much larger impact on that person. And like the policy that generally comes out of this committee, it's very much one-sided. It uses the legislature as a means to collectively bargain on behalf of the employees in the state, which I don't think that's what the legislature is intended for. That's just one of the many themes that tends to reoccur on the bills that we have in this committee. But it is a very common one, and it's certainly quite prevalent in this situation. I have a couple of questions about the language of the bill, and then I'm going to kind of give my take in some more detail about what I think about this. A few questions came up to me, Madam Chairman, during the discussion. And a lot of things were answered as well. So I actually had a lot more questions, but I still have a few that I'd like to address. I think it is in section 3 still. The section that starts on line 264. This is about the relationship between employers and employees, about how those employees are to indicate to the employer that they're taking the time off and what it was for. Can I ask a question first and foremost? Is there anything in this bill that says that the employee has to provide any notice at all to the employer that they're taking the time off?
On line 258, if you need to use paid sick leave, an employer may require advance notice not to exceed 7 days prior to the date such leave is to begin.
I appreciate that answer. I would ask you to read the next line of that same paragraph for me, if you would.
If the leave is not foreseeable, then an employer may require to give an employee to give notice of such intention as soon as practicable.
Understood, which means that there really isn't a requirement. Even though there is a specification for 7 days, it immediately nullifies that in the next sentence, which just says the employer may require the employee to give notice as soon as practicable. And I assume the determination of what's practicable is left up to the employee in this particular case. I think it's also interesting that, we have another bill that we just passed out of this committee on a joint favorable report that says that employers have got to provide 2 weeks notice to employees about any change in their schedules at all. And in fact, if they don't do so, they're going to be penalized in numerous and significant ways. And so it's quite clear that there is intention here to put weight on the scale for one of the parties in these transactions. And very clearly, it's an intention to advance the employee and their interests ahead of the employer. And, I've mentioned many times in this committee that it's very frustrating that the bills break down this way, that it's the employer versus the employee all the time. And because most of us, I think, particularly people in the business world, do not look at the world that way. People that are in business together look at themselves very often as partners that are working on their mutual success. I know that any place that I've ever worked, I did not have an adversarial relationship with my employer. I was not trying to put them into a corner and treat them as an enemy to get what I wanted from them. I communicated with my employer directly and had a conversation about what our circumstances were and how I could improve my own circumstances and station in life through my employment with them. And they did the same with me. This type of legislation flies in the face of that. You are creating more division in our society every time you interfere with the ability of people to communicate with each other and to work things out. Moving on later in this section, this is a pretty lengthy series of paragraphs about what notice is required and so forth. But effectively, as I just pointed out, no notice is actually required. There's this thing about 7 days, but then it says, as long as it's, practicable. So that kind of nullifies that. So the employer is not really due any notice, which I'm not going to say is not reasonable in the circumstance that somebody is actually sick. But the fact of the matter is, I don't know that it even goes so far as to say that the employee has to provide any notice at all. They could just not show up. The way I'm reading this bill, and the employer still takes a chance if they decide that they want to have some sort of response to that circumstance. Trying to read my own notes here. On lines 273 through 275, it talks about what an employer can require from an employee. And really, I think it breaks down to if it's 3 or more days, maybe the employer has some recourse, some remedy to the employer. The chairman used that phrase. But if it's under 3 days, it doesn't look like they really have to do anything. This says a written statement from an employee affirming that such employee is using or has used paid sick leave for the purpose of said subdivision shall be considered reasonable documentation. So the employee gets to write a note, not a doctor, the employee themselves. Can I ask, Madam Chairman, if I was an employee and I just wrote a simple note that said I was out because I was sick? Would that satisfy that requirement that's in the language of the bill?
I believe it would.
Yeah, thank you for that answer, Madam Chairman. And people wonder why there's no votes on these bills, because that's absurd. And I think it's intentionally absurd. There is, pushback from folks saying, you need to make this more fair. This is a very one-sided bill. And the response from the people crafting the bill is to insert language like that, which, it intends to mollify those concerns, but it does nothing. It does nothing. There's really no recourse for the employer under those circumstances. And moving on under subsection 3, starting in lines 286 and so forth. So if the employee is out for 3 or more days and the employer, has concerns, maybe they suspect that the person is not out actually because they're sick, but for some other reason, and they ask them for some sort of documentation, this is what it says. It says if an employer requires an employee to provide documentation for paid sick leave under the section, and such employer does not offer health insurance to the employee, and I'll just remind folks that this bill is going to apply to all employees, including part-time and including very part-time employees. It says the employer shall pay all out-of-pocket expenses the employee incurs in obtaining this documentation. So, how is that realistic in this arrangement? That the employer has got to go through a mountain of hoops just to run their own business. There's a lot more to be said about the language of all 3 bills. And if one of them or more of them ends up before the Senate, we can certainly talk about the details of the language. But I just want to talk about this more generally for a few minutes. A few things. First off, I don't like this being called paid sick leave or paid sick days because it's not paid sick days. It's paid time off. There's very little in this bill that is going to require anyone to actually be sick or to verify that they are actually missing time from work for being sick. It's paid time off. And I'll also point out that, you know, the folks that are pushing this bill are presenting it as if they're doing some very generous thing for employees across the state. And I'm telling you that they're not doing anything generous whatsoever. They're giving something that does not belong to them, first and foremost, which is the number one issue that I have with it. It's not yours to give. And by forcing someone else to give something that belongs to them to someone else does not make you generous. It doesn't make you kind. It doesn't make you moral or righteous. It means that you have very little respect for at least one party to the transaction. And I would say it means you have very little respect for our system of laws and justice, period, because our system is based on the idea that the people are in power and they have the sovereignty and the rights to make their own decisions. And people seem to think that when they're elected to this legislature that they can just come up here and decide how other people are going to live. And they're wrong. They shouldn't be doing that. And I long for the day that the courts finally get this right and start to push back on the ability of governments to be able to interfere in the freedom of private individuals to negotiate and come up with employment terms on their own. I talked a little bit about the themes associated with this committee. I think I already mentioned the notion of an antagonist relationship, and I know Representative Weir mentioned it also. That's not the way the world works. It really isn't. Now, I know that you know, some folks in the majority that like this legislation, they come from a world of collective bargaining and union labor, but that's not the whole world, first and foremost. And I don't know that even in that world that there is necessarily a very strict and adversarial relationship between the unionized employees and the employer. They tend to negotiate and work things out amicably in most circumstances. And certainly when there is no collective bargaining going on, that happens all the time. I'll also remind this committee that, you know, I think something I said the other day, which is that employment is a voluntary activity. The employee, if they don't like the terms, they don't need to be employed by that employer. And every employee and every employer has the opportunity to negotiate the terms of employment when they begin their relationship. And I say that kind of tongue in cheek, knowing that they don't really have the full authority to negotiate that because this body and the federal government have decided many things for them already. But everything that is decided for the parties eliminates a little bit of their freedom and ability to negotiate on their own behalf. And that should not be lost on people, even people that are getting a benefit. They should realize that they may have been getting a benefit, but they gave up something in exchange for that. And that was their own freedom to negotiate the terms of what they're getting. That freedom is what separates us from the rest of the world. In America, people are not born and then told that they're going to be royalty or they're going to be middle class or they're going to be slaves. In America, they tell people you are born equal with opportunity to be able to come and achieve anything you want. In other countries, that you might, go to school and they might tell you what you're going to do for a job for your life. That's the way this is going. We have government telling you what your job's going to look like, what your compensation is going to be. You should be able to achieve anything, and you should be able to negotiate those terms yourself. Point in fact, this bill and many like it that go through this committee are effectively using the force of state government, which is the most powerful force we have, government, more powerful than any employer, more powerful than any individual. Government has the force of the military, the police, the court, jail. So when the government says you have to do something, there's nothing more threatening than that. And the majority is using that force, the state government force, to tell businesses that they have to comply. And they're effectively using this legislature to collectively bargain with the power of that force behind them. What an unbelievably scary thought. Is there any wonder when you start to compare Connecticut across the the realm of the entire United States, the other 49 states, where we stand as far as economic viability, friendliness to business, job opportunities? We end up near the bottom on that scale, and that is exactly why. I've already alluded to the other theme, private contracts. It's a private contract between the employer and the employee. It's between them. Those are free people. They should decide what the terms of that agreement are. And they can decide whether they want to sign up for it or not. One side of that contract, either side, it would be wrong in either case, but neither side should have the state sitting next to them with all of the force and power that I just mentioned to tell the other side what they have to do. I won't even get into a discussion of capitalism versus communism or Marxism, which is, this is more aptly described as, because we've had the conversation so many times. But I'll just remind people that capitalism is what made America great. It is why we are still a great country, that we still have a mostly free economy where markets decide outcomes. And yes, they are not equal outcomes. But all other systems that strive for equal outcomes mean worse outcomes. The quality of life that we have in this country is a direct result of the freedom and the capitalism that has created the incentive for people to go out and achieve and make great things. There's also no free lunch, something I say in here all the time. And that is because, as I mentioned, the legislature doesn't have the power to give anyone anything. They only have the power to take it and to give it to someone else. They don't actually create anything. They're not actually making the paid sick days and handing them to people. They are taking them from someone else. And as I mentioned, that does not make anyone holier than thou. It does not make anyone moral or generous. It means that they have little respect for the parties involved. And the fact of the matter is that employers, if they are forced to comply with any particular requirement that is placed on them by state government, they're simply going to make up for it in some other way. And what will be lost in the process is two things. Well, three things. One is the freedom of those people to have chosen some other path. The second thing is the right of the employee to have negotiated something that they would have preferred to the paid sick days. Because since that's off the table now, and the employer has to give them the paid sick days, they cannot negotiate the value of those sick days in some other way. They can't negotiate that for, some other benefit, mileage or, different hours, or God knows all the things that could come up in any type of employment that someone might want to negotiate with their employer. You are putting the employer in a box that they only have certain amount of things that they can actually work with now to negotiate with the employee. And therefore the employee is not eligible to be able to negotiate for those terms that they would wish to have either. And the third thing is that we are diminishing the production in our society. These type of regulations tell businesses not to come here, not to expand here, And ultimately, even if they do, they're limited in the amount of production that can actually occur because they are busy complying with state government regulations by force. And I'll give you a quick example, which is that I'm a very small business person. I'm a realtor, an insurance agent. I own a couple of properties. And I often think that I want to hire an assistant to help me with these things, especially when I'm here busy at the Capitol. I need someone to fill in and answer some phone calls and take care of some paperwork for me. But I haven't hired somebody. And I will tell you the number one reason why is this place. It's because I can't imagine the amount of paperwork I'm going to have to do just to hire someone and pay them a wage to be my assistant. I won't be able to negotiate the terms that I want. I will have to follow a bunch of requirements in state law, fill out forms, comply with regulations and requirements about insurance, workers' compensation. I'm going to have to offer paid sick days. And I'm going to have to track all of that too. That's one thing that we don't talk about enough of in these meetings is the amount of requirements that are put in these bills for employers to track everything. We're going to talk about the warehouse bill later. I mean, that's the worst part of that whole thing. You've got to keep records for all eternity about every step every person took in that business from the dawn of time. And we're going to track it. And if you don't have that, boy, the government will come knock you on the head. So let me just close by saying this. And that is that this bill's got a lot of problems. It's morally wrong. It interferes with people being able to negotiate the terms of their employment on their own. And it's unnecessary in our society. The market would determine how much certain employment is worth to employers, how much employees will take jobs for what type of pay. That all gets figured out by the marketplace. This interrupts that marketplace and not in a way that will be beneficial to anyone. And I think that's clear based on everything I've said so far. But the final thing that I would just say about this bill is that it is unbelievably arrogant, in my opinion. I mean, that's the thing that annoys me about it more than anything is just how arrogant it is to think that people that by virtue of being elected as a state representative or a state senator, that they have the right to tell other people who live in this state, who work hard every day, doing whatever they do, that we can just decide at a moment's notice that we're going to stick our nose in their business and tell them what their employment agreement is. It's not our business, Madam Chairman. We should stay out of it. I'll be a no on this bill. Oh, actually, the first three bills. Thank you.
Thank you. Any other comments or questions? Seeing none, I would ask the clerk to call the roll. This is on the first item on the agenda.
A roll call vote has been requested and a motion duly made and seconded on agenda item 1, Senate Bill 7, an act concerning Connecticut paid sick days. The motion is to JFS the bill to the floor and the relevant LCO is 3333. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert, Representative Belton.
Votes yes.
Representative Belton, I didn't hear that.
Belton votes yes.
Thank you, Representative. Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Madam Chair.
Thank you. We will be holding votes open. The next item on the agenda is item number 2, Senate Bill number 12, an act modernizing the paid sick days statutes. It's a JFS to the floor, LCO 3336. So moved. It's been moved by Representative Hughes and seconded by Representative Wilson. Are there any comments or questions on the bill? Seeing none, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 2, Senate Bill 12, an act modernizing the paid sick days statutes. The motion is to JFS this bill to the floor. The relevant LCO is 3336. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert, Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Madam Chair.
Thank you. We will be holding votes open. We'll move to item number 3 on the agenda, House Bill number 5005, an act studying paid sick days, JFS to the floor, LCO number 3334. Seconded. It's been moved by Representative Wilson and seconded by Representative Hughes. Any questions or comments? Seeing none, I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 3, House Bill 5005, an act studying paid sick days. The motion is to JFS to the floor. The relevant LCO is 3334. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert, Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Madam Chair.
Thank you. We will be holding votes open. Item number 4 on the agenda, Senate Bill number 412, an act concerning the protection of warehouse workers in the state. It's a JFS to the floor, LCO number 3240. There a motion? Seconded. It's been moved by Representative Wilson and seconded by Representative Hughes. Is there any comments or questions? Senator Sampson.
Thank you, Madam Chairman. I always wonder about the titles of these bills. This one might be more aptly named an act eliminating the opportunity and for warehouse jobs in the future in the state. I understand the intent behind this bill, and certainly we want to make sure, as we've had this conversation in the last meeting also, that workers in the state of Connecticut are protected. I mean that is a legitimate responsibility of government. But I'll just reiterate that we've gone a long way from protecting children from working in the mines to now regulating every last bit of what happens on the job. And I think that this bill goes too far in a lot of ways. First and foremost, it fails to recognize that employers and employees are the ones that are going to determine what is acceptable as far as requirements for the day-to-day work that is required for any given job. And this takes that away effectively and starts to put it in the hands of the state government to dictate not only how much people are paid, not how much benefits they get, but now we're going to talk about, how much work they have to do and what the responsibility of the employer is to actually track the data for their work, all for the purpose of eventually putting an employer in a predicament. And I'm not suggesting that employers that are unfair or dishonest should not be punished. I certainly believe that. But the number one remedy for that is employers who are mistreating their employees should lose their employees because their employees say we're not going to work for you anymore, and choose a different employer. And hopefully the market solves that problem because quickly people find out that they can go work for someone else to earn a better wage or have better working conditions doing the same job. Well, that other first employer will fail. The problem with our whole society is that the government is sticking their nose in everything. We're not allowing bad businesses to fail. We saved the banking industry. We're saving, large corporations all the time. This is not the way we should be doing things. Businesses should be allowed to succeed and fail, and the market should be allowed to actually resolve those situations on their own. This becomes nothing more than another impediment for someone who wants to open this type of business in our state. And the fact of the matter is there's little recognition by this committee and this majority that we're in competition, with 49 other states and the rest of the world. And when business owners and operators decide that they're going to put, a facility somewhere, they're looking at us. They're looking at what's going on in the state. The same way I am reticent to hire an assistant for my small business because of the red tape and requirements. I'm certain that someone is operating a warehouse is even more wary of what the requirements would be in Connecticut. I was going to ask a lot of questions regarding the establishment of quotas and determination of work speeds and what the exceptions are. But it's probably not worth engaging in today. And I'm certain that the people listening don't want to hear every word of the bill. But I'm certain that the people that are impacted by it are going to be directly concerned and very aware of the language of this bill and how it's going to impact their industry and their future opportunities in Connecticut. I will just reiterate my concern I mentioned a few minutes ago about the level of record keeping that is required. In section 4, starting on lines 85 through, I don't know, the whole section 4, I guess, through 96. It says employer shall establish, maintain, and preserve contemporaneous, true, and accurate records of the following: each employee's own personal work speed data, the aggregate work speed data for similar employees at the same warehouse distribution center, and the written description of each quota that each employee was provided pursuant to the earlier section, the other reporting requirements that are already in there. I mean, it's just like, you're basically eliminating an employer from being able to make a decision based on their observation that they have an employee that is not fulfilling their obligation as far as the amount of work that they're doing compared to the other employees. By making it so onerous for the employer to actually track that and be able to prove it. And effectively, that's what's going on here, is instead of the current situation we have in Connecticut, which is at-will employment, where the employer says, look, sorry, Rob, you're just not cutting it. Everybody else on the floor is able to, move 24 pallets a day or whatever, and you're only doing 18. I've asked you every week, you got to step it up, but you're still not doing it. So I'm going to have to let you go. That's what can happen now. But I don't think that happens once this bill passes. I think when this bill happens, then Rob gets to go and file a complaint, with the court, or get the AG. Why are we including the attorney general in almost every one of these bills these days, to empower the attorney general to take sides in a labor dispute in an at-will employment state by creating causes of actions in our law? I mean, that's what's happening here. It's bit by bit an erosion of the ability of people, sovereign people, employers and employees, to go and live. We're just injecting conflict, division, lawyers, and we're taking away freedom and the marketplace. I'll be a no on this one too. Thank you, Madam Chairman.
Thank you. Any other comments or questions? Representative Weir.
Thank you, Madam Chairman. And I wanted to ask a few questions. I also have a few notes set aside here. I would say that this, if you think of warehouse bill, we did see this last year. And if I think of any other company, who's building these large warehouses, who's employing people, who's coming into our state and investing? I mean, it's Amazon. I mean, I'm not aware of anybody else. Maybe I'm, you see their warehouses popping up, and I don't understand. There's so many people who rely on their deliveries. I guess if this bill were to go forward, I'm trying to think, what would their response be? Trying to operate a quality business. We all depend on getting our packages delivered on time, in good shape and efficiently. And so, I frequent Facebook, as I'm sure, and social media, so I'm sure some of us do. And I can't tell you the amount of posts on the community pages around the holidays, like my present didn't show up, my gifts, Amazon said it would be here, or it was delivered to the wrong house. Has anybody seen it? I'm sure we can all relate to those. You know, we depend on these companies delivering food, food items, groceries, all sorts of different things come from Amazon. We expect it to be, like yesterday, delivered yesterday. And for that, I would imagine there have to be some performance standards set at their warehouses. There have to be. We talk about, Senator Sampson alluded to the far cry that we are today from where having children working in the mines of decades ago, at least in the United States. We have Occupational Health and Safety Administration, OSHA, to protect workers and make sure that there's an outlet to have a safe work environment. Additionally, good companies want to have a safe working environment for their employees because they rely on those employees to be able to safely work today so that they're healthy and able to safely work tomorrow and the next day, because without employees, the company can't produce. So this is a relationship that works well, and it works best without our involvement when the two parties can work together to achieve the goal. In this case, it's delivering packages. So we're talking about, if I go down the line, page 1, and again, we're talking LCO 3240, that, we're going after, this is really focused on warehouses with 100 or more employees at a single warehouse or 1,000 or more employees in aggregate. And it talks about corporations and limited liability companies. But this is really, it's directed at Amazon. Let's call it what it is. And going through my notes here. I'd like to just ask a question on section 2, page 2, lines 47 through 52, where it talks about the employer shall provide to each employee no later than August 1st, 2025, for an employee hired on or after 2025, a written description of each quota that employee is or will be subject to. I imagine that it's a good idea to have that an employee knows what their expectations are. I mean, how would you go into a job not knowing what your expectations are? I didn't hear testimony where people said they didn't know what the expectations were. We heard testimony from people saying that the quotas can change, performance can change, which makes sense. But I don't see how. I find it hard to believe that an employee would not have a written description and a clear understanding of what the expectation is to perform in a given amount of time. So I'll ask a question on page 3, lines 57 through 59, and we talk about, it says the employer shall notify the employee of such change as soon as possible, either verbally or in writing, if there's a change in the quota or the performance measure prior to such employee becoming subject to the new quota. So what's the intent of this language for the phrase as soon as possible? That to me, that's subjective.
I believe the intent is that as when an employer is changing the quota, that they have to notify the employee immediately, as soon as possible.
Okay, to me, that's, again, because we are creating law, I think that opens it up to, this is a subjective, if the employee said, geez, as soon as possible to me means the minute that I report to work and there's a change. The employer may say, as soon as possible is at the end of the week or before the next pay period or whatever. If there's not a clear understanding between the two parties as to what that means, and now we're involving Department of Labor and the Attorney General as the heavy hand of government to go after the employer, I'm concerned that we've left this open. I'll just make a note of that, but next down in section 3, which is new, talks about what the quotas cannot be, right? Or what a quota cannot do. And I see, I don't know the general statutes about meal periods. I mean, I understand it to be a meal period every 8 hours is my recollection, but I won't go there. It sounds, it's probably just conforming with existing law. Seems reasonable. Interfere with an employee's use of the bathroom facilities, including reasonable time, travel time to and from the bathroom facilities. Again, reasonable is subjective, but I have to imagine that if you're working at one end of the building and the bathroom is 500 feet away, you know, I imagine if we're talking about these logistics companies and warehouses, they rely a tremendous amount, tremendously on technology and data and statistics. So I'm sure that they know exactly how many steps it is to the bathroom and how much time it would take the average employee to get to the bathroom. And maybe that's measured, I don't know. But if it takes 2 minutes to walk there and you add up that 2 minutes to walk back plus whatever time somebody's spending in the bathroom, and let's just say it's a total of 10 minutes and the employee is in there for 20, well, maybe that's going to raise a flag. Maybe that's going to be flagged and say, hey, everybody else is in there for 10 minutes. You're in there for 20, which is 10 minutes left of productivity, which means our Christmas presents didn't get delivered. I can see how that would be measured. And also be reasonable to track and determine a reasonable amount of time. Can you, Madam, this is a question on number 3, line 71. Why can a quota not measure an employee's total output over an increment of time that is shorter than an employee's workday?
I think this is intended precisely to address the issue of the break times that people typically will take. And so we don't want a situation where someone is being penalized with an hourly quota because they had to go to the bathroom during one of the hours and thus has to make it up in the next hour by working twice as hard.
Okay, thank you for that explanation. I was looking at this from a little bit different perspective, thinking that if there's there may be peak hours, there may be certain times when delivery trucks are going in and out, and so there may be maybe a heavier push, if you will, or peak hours where the numbers are going to be up and people have to handle those numbers, and then there may be maybe that's the morning, right? The trucks are going out at 7, so your peak hours are going to be from 3 in the morning until 7 in the morning, and then there's a lull, and then they're back, and delivery trucks do work in cycles, coming and going. So I was just looking at that from a different, but I guess I can see that, but I think this language may miss the opportunity for a company if there's a peak hours. If you think of the restaurant business, a pizza restaurant Friday night, is jammed, but maybe Saturday afternoon at noon isn't so busy, and so Friday night there's additional resources put in towards those peak hours. Just want to make that put that on the record. Why does this bill prohibit quotas based solely on ranking the performance of an employee in relation to performance of other employees? And if I didn't state, I'm sorry, that's number 4, line 72 through 74.
I think that the purpose of that is to protect against an employer forcing such speed up that employees are hurting themselves, becoming damaged because they're trying to keep up with somebody who's faster, who's right next to them.
Okay, and I can see, somebody being concerned with maybe being put next to somebody faster. I mean, I have to sit next to Senator Sampson and observe him and try to keep up. So I recognize that it's not an easy thing to do. But I would also point out that many of in many parts of our life, I mean, in sports, we're all looking forward to seeing the UConn basketball team play tomorrow, I think, tomorrow afternoon, and the players on that team and any other team for that matter, they're positioning for playing time. And the way they're getting their playing time is by showing the coach that they're going to outwork the next guy. And that goes same for the women, and we see it in sports. Companies do it. They compete against each other to have the best product and who can deliver it faster and quicker and with better service. And I think we're missing out by putting that in there that I think employees, it's not a terrible thing to have employees judged against one another, because if you have 10 people performing 100 widgets an hour and you've got the 11th person only at 50, to Senator Sampson's, may not be working out. And so not to be able to measure them one against another employee, I think that is probably one of the most restrictive pieces of this entire bill.
Representative Weir, I do want to point out, it says solely. It says it can't be a component, but it says it can't be solely based.
Okay, so it can be a component. Thank you for pointing out the word solely. I still think it's pretty, pretty restrictive, because if somebody, if an employee is saying, look, I was only judged on how I compared against my peers, make that allegation. And again, we're involving the Attorney General and the Department of Labor. All right, number 5 in that same paragraph, lines 74 through 76, says that a quota may not measure, record, tally increments of time during an employee's workday where such employee is or is not performing a particular activity or set of activities. Can you give an example of what I was confused by, what that's trying to achieve, the intent of that paragraph?
I could envision where an employee would be taken off their normal tasks that their quota was comprised of, was based on, taken off those tasks and asked to do something else for the employer, or go to the office and pick up an item from the office and take it to the manager's office. That would be time spent off task.
Okay, so if they're not performing their tasks, they won't be measured. That understood that. So is there a place in this bill that you're aware of that if an employee exceeds the performance of the quota, where they could benefit from that, where perhaps if they're exceeding past, in relation to their peers, or exceeding the quota that was set, that this could, in essence, put them up for a raise or some sort of recognition? Does this bill at all address that?
This bill neither requires it or prohibits it.
Okay, so for an outstanding employee exceeding any quotas that were set, that employee, he or she could receive a raise or a bonus or whatever type of recognition that the employer decides. Okay, thank you. Page 4, just flipping the page, in section 4, lines 85 to 91. Again, talking about, this is talking about the employer shall establish, maintain, and preserve contemporaneous, true, and accurate records of the following. And they talk about the types of records, the employees. I'll just go through it. I think Senator Sampson may have, but I want to make sure that I'm being clear here. Each employee's own personal work speed data, the aggregate work speed data for similar employees at the same warehouse distribution center, and the written description of each quota that each employee was provided pursuant to section 2. So who gets that information? Where is the employer required to just store that and keep it available in case somebody requests it?
That is my understanding.
Okay. And on lines 92 and 93, I'm reading a paragraph, just 2 sentences, 1 sentence that I want to understand the intent. An employer shall maintain and preserve any records required pursuant to this section for a period of not more than 3 years. What is the intent of that sentence?
I believe the intent of this is to ensure that if there is a complaint that is raised, that the employer would have maintain the data for purposes of establishing whether or not that complaint was warranted or should be rejected.
Okay, so the intent is to have them maintain the records for 3 years.
That is correct. And I do want to point out, these are electronic records that I think everyone understands that we're talking about highly mechanized and record keeping in these operations.
Thank you for that. That makes sense with the electronic. It's to Senator Sampson's, as he brought up, there may be technology that exists that says that, at this date, this is getting purged, but usually there's some sort of manual, requires a person to make that decision. So I think, again, it's another mandate, it's another encumbrance upon, it's another added task that needs to be done. But I would point out, the way I'm reading this is that the employer, in other words, must purge at 3 years, where I think the intent was to keep for at least 3 years. So I would want to have somebody look at that to see if I'm off my mark.
I agree with you. The intent is that they would maintain it for at least 3 years.
Okay, thank you. Looking through my notes, bear with me for 1 second. I had one more question here. Yeah, I will just point out something that I see as a potential problem. This is in section 6, 123 through 127. And it talks about on and after July 1st, 2025, no employer shall discharge or in any way retaliate, discriminate, or take any adverse action against an employee or former employee after such employee makes a request pursuant to Section 5 of this act, which was what we just talked about, requesting the records on their performance, or files a civil action pursuant to Section 7, which talks about all the various ways that the state can bring enforcement action on the employer. And I would like just to point out that, we talked in housing, we've talked in this committee about bad actors in certain settings, whether that be professions, and in some cases you have employers who are bad actors, and in some cases you have employees who are bad actors. And I just want to make sure that we're not setting up an employer for failure here, where maybe an employee has been put on notice of lack of performance, been put on a performance improvement program, they're not meeting the quota, they're not matching up to their peers, at which point that employee, maybe they're on their way to getting a final warning or discharge, and the employee senses that coming and makes a request for records or files a civil action, and now the employer is prohibited from it looks like retaliatory, even though there may have been entire set of circumstances that was, the next step was going to be termination, and now because the employee has taken this action, he or she may have bought additional time, or brings in the Attorney General, brings in, the Department of Labor to weigh down on the employer. So I want to point out that as I'm looking as to what could go wrong, what's an unintended consequence of our acting, I'll just note that concern. I think I'll just, I want to point out, I have no further questions. I want to point out, we talked about, the OSHA is involved. Nowadays, the employees and employers alike have the benefit of working with OSHA, because employers can work with OSHA on the front end to have surveys of their facilities to make sure that OSHA can act as a resource, not just an enforcement arm. I would point that out to help employers make a safer working environment for their employees. Employees have that recourse if something happens, if there's an unsafe work environment. Safety should be really above anything. Safety should be the priority one before delivery, before profit, before service. Safety has to come first. And we have that, that exists in so much of our, um, so many of our regulations point us in that direction. So I'd like to just close with the fact that I think Senator Sampson pointed out that we have an at-will environment. This is an at-will state. Employers today are screaming for good employees. And so employers who don't offer a safe, safe work environment, one where employees are rewarded, where they're happy, where they're content, where they're challenged. I don't know exactly what every employee is. Different employees are looking for different things, but if they're not in an environment that's suiting that employee, they have the freedom to move and find an environment where they're going to be satisfied. And it behooves employers to create an environment without the force of government. They're already doing this. If they don't, they're not going to retain employees if they're not creating an environment where the employee feels valued, where the employee is able to bring home, a pay that's able to feed and take care of their families. So I think we have to remember that we're really interjecting ourselves here, I think, unnecessarily. The last thing I will point out is that in the testimony, I observed that the Department of Labor opposed this legislation. Their commentary was that it was going to be difficult to enforce. So I will be a no on this legislation. I thank you for indulging me with the time.
Thank you. Representative Yakarino.
Thank you, Madam Chair. I'm going to be pretty brief. With Senator Sampson and Representative Weary asked really most questions I wanted to ask. I did listen to the testimony of the warehouse workers and I'm sympathetic. I worked, I was in the Navy. My buddy was in the Marine Corps. We both joined the Marines together, but I switched services. We got a job at a Johnny Barton Liquor in North Haven. It was a big warehouse when we were, I don't know how old we were, early 20s or 21 or whatever. And we used the competition. We would unload these cases of magnums of wine. I don't remember how much they were, like 60 pounds a case. And we would have to unload everything off the train, put it on the pallets, not break anything by the end of the day. We would compete and we did it. We were proud at the end of the day. We did that. We met our quotas. We did everything we had to do. So I think competition is a good thing. And I think, correct me if I'm wrong, on the books today, if you have to use a bathroom at any facility, no employer could stop you. Am I correct? Madam Chair, I'm sorry. So I think that there's labor laws currently that nobody could stop a person using the facilities.
Hold on one second.
Thank you.
As I suspected, there's nothing in statute that says you must allow someone to use the bathroom. I think the issue here isn't about whether or not they stop a person from using the bathroom. It's whether or not that time that they spend going to the bathroom is counted against them on the quota.
So I appreciate that answer. So I'm guessing we're talking about one company, not all companies. Because the company I work for is still in business and they have over 100 warehouse employees. They sell wine and beverages. And then there's lumber yards that have over 100 employees in Connecticut. There's a lot of warehouses in Connecticut besides Amazon. And listen, if they have bad practices, the Department of Labor, the Attorney General, they should address those. And the employees should address those. And they think they have the right to address those without this legislation currently. But we're looking at, like I said, the company I work for is still in existence, which is a union shop. Now, it was a union shop then, but we weren't in the union because we had just got off in the military. We were just working summer jobs. But we all competed and worked really well together to do a good job. And we did. I think like a lot of the bills that maybe are well-intended on your side that become adversarially, they become us against them. And if there's an issue with one company, the workers should address those. They should either have the right to do what they want to do. But I think when you have an employee, there's section, I think is it section 3? Oh, no, sorry. I marked it up well, there's a section, I forget what it is, but if a former employee wants to bring grievance against their employer months later, and they go to another employer, why didn't they do it ahead of time? Or they could get an attorney to do that. They could currently do that now. I don't know if this legislation, I just don't, I think there's remedies now. That's my point. There are remedies now to go after an employer if need be. And if the Department of Labor is not really supporting this, maybe they should think about supporting in the future as far as doing what they're supposed to do and not have this legislation. Because there are laws in the books where you can't you have to give people time to go to the bathroom. They have to get a meal break. They have to get a lunch break. They have to get a dinner break. That's existing law. Am I correct?
The issue of this bill is there's nothing in existing law that says that an employer cannot use those break times, is prohibited from addressing those non-work break times in their quota. There's nothing on the books like that.
I believe there's on the books every 4 hours, you have to get a break.
I agree that there are times you have to get break that are written into the statutes. There's nothing that prohibits an employer from saying, because you're taking your break, I'm going to fire you or discipline you because you're not meeting your quota because you spent part of that time on your break.
I think that's against the law. You cannot fire somebody for taking a break. You cannot.
I think you're
You cannot fire-
misunderstanding.
I do
I-
understand.
No, you're misunderstanding my response. It is not the question of whether or not you get to take a break. It's a question of whether or not your quota is reduced for the time that you are on break. The quota requirement.
I follow you. I get
Okay.
it. So I guess for me, I'll speak for myself. If I know I have a certain quota and I know I have to do a certain job and I know I'm gonna have 15 minutes for break, half an hour for lunch, and then another break, I have to either pick up the pace or take a few minutes less. But at the end of the day, I knew going in, I had a job to do. Now, again, I was sympathetic to some of the warehouse workers. I did that when I was younger, and I did it when I was, before my business at UPS for a while. And I liked it when I was a kid. I didn't like it when I was older because I just wasn't something I wanted to do. But I had a young family, I had 2 jobs, I needed extra money. And I knew going in what I had to do. I got beat up, packs just fell on me. I just like, go, like I was back in boot camp. The fact is, I knew that going in, and eventually I didn't like it. I quit. No ill will. I just wasn't for me. I opened my business. And I'll go back and I'll end it with this. There are laws in the book to protect workers, and we should have laws to protect workers. They should be protected. But we're going after one particular company, I believe, but there's a lot of companies that might fall into this that have a great working atmosphere and have people that work, the company I used to work for, people are there 30, 35 years for a reason. If there's an issue with this one company, they can be addressed, but there's laws in the book to address that. No man or woman should be denied going to the bathroom. And I don't think that's the case. If it is, that's a problem. But nobody should be denied going to the facilities. So I'm sympathetic to the workers, but they have to make a decision. And if they have those quotas ahead of time, they know what they're getting into. And if they don't feel comfortable with that, try to go work at Johnny Barton, go work at a lumber yard, go work at a farm that has a big warehouse. There's plenty of warehouse work, and there should be warehouse jobs. But again, I know you have the right intent. We just don't agree. So thank you.
Thank you. Any other comments or concerns, questions? Seeing none, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 4, Senate Bill 412, an act concerning the protection of warehouse workers in the state. The motion is to JFS the bill to the floor and the relevant LCO is 3240. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert,
No.
Representative Belton. Representative Belton, you're muted.
Belton votes yes.
Thank you. Representative Hall, Representative Hughes.
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino, no.
Thank you, Madam Chair.
Thank you. We will be holding votes open. Item number 5 on the agenda, Senate Bill 414, an act concerning equity in state employment. It's JFS to the floor, LCO 3228.
So moved. Second.
It's been moved by Representative Wilson and seconded by Representative Hughes. This proposed bill arises out of work that was done and required by the legislature by the Commission on Racial Equity and Public Health. It was established through Section 2 of Public Act 2135, where racism was declared a public health crisis. As such, there was a commission created to look at state government, look at best practices, and evaluate ways in which we can ensure that the state as an employer is making every effort to dismantle structural racism. And the recommendations that are contained within this bill were presented to the General Assembly in its report in December of 2023, the Commission on Racial Equity and Public Health. The main thrust of this is to ensure that every agency and every office of state government is intentionally addressing ways to ensure that the state government is an equitable employer, intentional about looking at issues of unconscious bias, and ensuring that there's equal opportunity or equitable opportunity for every employee and for every prospective employee within the way we operate as a state. The main thrust of it is to require equity directors in each agency and also in the offices of the constitutional officers. I will say that there is ongoing discussion about this bill between the executive branch, the commission, and the legislators. I do believe this is a bill that is a work in progress. I don't say that too often. I rarely say it. I think it's said a lot more in other committees. But in truth, I have been advised that there are folks in every area that would like to have further discussion about how this bill is crafted. I think there's a general commitment by all of us to address to make every effort to address structural racism and and be the best employer that Connecticut can be. But I think that there's going to be further discussion about how we accomplish that. So having said that, I know I'm sure there are questions and comments that people want to make. Any? Representative Acker.
And thank you, Madam Chair. And I just left the committee. I think all the bills are a work in progress. So to your credit on that, I'm just like, aye. So, as you know, legislators multitasking at times at this time of year. So I did want to make, listen, I think our state, nothing's perfect. Nothing can be perfect passage of this legislation. But I think our state and our departments and our commissioners do a fantastic job. And the people under them do a job. And each year they have to do an analysis of the employees that are under them, and to look at this. To me, this is already being done, and I think that they've actually taken the lead throughout any of the businesses in the state of Connecticut. And we could be. I think we are a model. What we might find, and I did a study, I think we had a similar bill come up last year, is that actually, and because I'm one of them, it's the older white gentlemen that aren't the ones being, that aren't typically in state service, maybe in our construction departments and things like that. But that we have a very, very good balance, I believe, already in our state employment. And I think our commissioners are focused on that. And I think this administration is focused on that. When I look at the opposition, it's essentially we're creating another department here, or individuals in the department to see this, when I think that this is already being handled successfully. So my simple comments is, I believe that we're on the right track in Connecticut. I don't think we need legislation like this to improve what we're already doing. I look forward to any language that may change this, that moving forward. And if the OPM secretary is going to weigh in and put some guidelines to it. But I really think we are, those resources, although laudable, but I think we're already there, or we're in the movement in the right direction, could actually be used for hiring more individuals that the departments could use. So as we mentioned, we're working on some of those areas that we want to fulfill some jobs and create more jobs in state government. So I will be in opposition to this in the state that it's in right now, but look forward to the dialogue or the upcoming changes that you may be presenting, or this committee may be presenting. So thank you, Madam Chair.
Thank you. Who's next? Representative
I'll be real
Yakarino.
quick, Madam Chair. And I want to align my comments with Representative Acker. I think I'd like to support this going, see how the language changes with the OPM secretary. And like you had said, Madam Chair, that it's a work in progress, but hopefully when it gets to the floor. But I think we're doing this in Connecticut now, and I think it's a good thing. So I'll wait to see what happens. That's all. Thank you.
Thank you. Senator Sampson.
Thank you very much, Madam Chairman. I don't know exactly where to begin with this bill. I've got a lot to say about it, and I want to go through the language of the bill as well. I guess I'll start by saying, just, for the record, we're discussing a bill, Senate Bill 414, an act concerning equity in state government, in state employment rather. And effectively what this bill is going to do is it's going to mandate the hiring of, I don't know the exact number, somewhere around 25 DEI directors, coordinators, commissioners, I don't know what they will be ultimately called, throughout state government. They will be highly paid individuals, and they will certainly be hired for the purpose of making sure that the policies of the state government, and in fact, there's a section in the bill that says that they will have the ability to review every policy in every department, in every agency, before they actually occur, to put their DEI spin on it. That's what the bill is before us. It's going to be extremely expensive. It's going to cost the taxpayers a lot of money, and I'm afraid that it is going to further divide our state and our nation. And that's where I start on this proposal. And I'll simply just put it this way, which is that there is a tremendous divide in our country politically, and there are a few different divisions, but one of them is a very clear one, and that is between people that, I'll preface it by saying that I think there's a legitimate desire from people on both sides of this equation to eliminate race and gender-based discrimination, and they both believe that they are doing it in the proper way. The fact of the matter is that objectively only one of them can be correct. And I'm going to make the case that this particular policy that is before us is the incorrect way to go about that, and that ultimately it will lead only to more discrimination and more division in our country. There are people like myself that are unapologetically colorblind. I believe that there is only one race. It is the human race, and that people should not be judged based on superficial things. Judging people based on color is as stupid as judging them based on their eye color or their shoe size or any other ridiculous superficial characteristic about the size of their nose or their ears, etc. It's ridiculous and dumb on its face. And people that continue to treat other people in a different way based on those superficial characteristics are small people who clearly have not thought it through. There's a lot to say about this whole topic because it involves a discussion of human history, and particularly America's history over the last couple hundred years, which I'm going to try and stay away from today. But inevitably it has to be some part of the conversation. My concern about this is that my view, which is that people should be colorblind based on the reasons I just stated, that we are one race and that we should not judge people based on superficial characteristics, is one point of view. The other point of view is the one expressed by the chairman in her remarks bringing out this bill and the purpose of the bill before us, which is that there are folks who believe that the only way to resolve the inequities of the past is to create inequities in the future. And that's what this bill intends to do. And that will be quite clear. I'll state from the outset that I think this bill is unconstitutional on its face. I believe the Supreme Court, in their recent decision regarding affirmative action, already laid out the reasons why, which is that you cannot promote or deny people access to things based on these superficial characteristics. This bill clearly does that. If there's any doubt about that, I will dispel that before this conversation is over. I can promise you that. And I'm going to have a lot more to wrap up with, but I think what we should do is go through the bill first. And I'll start by asking the first question, which is, Madam Chairman, Section 1 defines what, it's basically just definitions, but it lays out which departments will be required to have a DEI department head or director, rather, of DEI. Can you tell me, you can list them if you choose, but it might take you a while. Can you tell me how many state departments there are?
How many state departments there are that are not mentioned, the total number of state departments, or are you talking about those mentioned in this bill?
The ones that are impacted by this legislation.
I can count them. I believe the count is 26. But if you have other, I would defer to you because I'm sure you've already counted them.
Thank you, Madam Chairman. Yeah, no, it's a difficult thing to count because you're basically counting commas because some of our state departments have lengthy names. But I'm going to rely on the article that I recently saw actually, I don't have the publication in front of me. I want to say it was Inside Investigator, but I don't know that it was. Yes, that's who it was, Connecticut Inside Investigator. They say there's 24 in the bill. So it's somewhere in the neighborhood of 24 to 26. And as was mentioned, it's subject to change. I think that's interesting because, we were told that this legislation is a direct result of the creation of a state, I don't think it's an agency, the commission on racial equity and public health that was created by some legislation, I think in 2021. And they're the ones that came up with this recommendation to create this policy. But they were charged with creating a policy that addressed equity across racial differences in the area of public health. But I'm looking at the list of departments where we're going to install these DEI directors, and I discover places that have very little to do with public health. DAS, aging and disability, maybe. Agriculture, children and families, maybe. Consumer protection, no. Corrections, possibly. Developmental services, possibly. Economic and community development, I would say no. Education, DSSPP. Energy, environmental protection, insurance, labor, mental health, addiction services, motor vehicle department, and again, there's more. So 24 to 26 state departments that will have DEI directors, allegedly because of disparities in outcomes regarding public health. And yet there are many, many state agencies that have very little to do with the subject of public health altogether. Can you tell me why these other state departments would be included based on that premise, Madam Chairman?
I'm not sure I agree with the premise because I believe that the Public Act that was passed tasked the Commission on Racial Equity and Public Health with reporting best practices that state agencies can implement to reduce racial inequities and dismantle structural racism within state government. So I don't believe it was confined to public health.
Thank you, Madam Chairman. I will take your word for that because I have not gone back to look at the actual charge that they were given. I just am looking at the name of their commission as guidance, and it's Commission on Racial Equity and Public Health. So I'm very tempted to ask you about structural racism, but maybe we'll get there later. I'll start by talking about the definition of equity, which is on line 28 through 36. I'll read it. I don't like to read, but I want people who are listening to know what the bill actually says. And that it reads, equity means the consistent and systemic, fair, just, and impartial treatment of all individuals. If you just stop there, I would be more than happy. I might support this bill and co-sponsor it. But it goes on to say, who belong to underserved communities that have been denied such treatment, such as Black, Latino, Indigenous, and Native American persons, Asian Americans and Pacific Islanders, and other persons of color, members of religious minorities, women, lesbian, gay, bisexual, transgender, and queer persons, persons with disabilities, persons who live in rural areas, and persons otherwise adversely affected by persistent poverty or inequality. And the reason why I take issue with this is because we do not in America write laws based on groups. That's just not how we operate. We recognize that every person is an individual in America, and they are individually sovereign, and they have God-given rights that are protected by our Constitution, state and federal. And this bill throws that out the window and categorizes people by, in many cases, superficial characteristics or at least unrelated characteristics. To say that someone is underserved or been denied fair treatment just because they happen to be any of these things, I don't think you can say as a blanket statement. You can say that historically, different communities based on those superficial characteristics may have had different experiences, but that's true today, and that's true for everyone. And not everyone from each one of these groups is facing the same experience. Can I ask why, Madam Chairman, why these particular groups were chosen?
I do want to point out that just to be clear, and I know that you know this, but the way you stated it, you left out an important word in the piece of legislation because it says all individuals, including. And that word is important because it still covers all individuals, but it specifically addresses these particular groups. And you asked the question, why these? Because I think that there's been, upon this commission, made this recommendation because I believe they found in their examination of state employment and the work that they did, that these were groups of people that we need to particularly acknowledge may not always receive equitable treatment.
Well, I appreciate the term equitable treatment, but I would ask equitable treatment by whom? And I'd look for an example of that. And I would also ask you to provide for me something that would suggest that all people within any of these groups experience that same disparate treatment.
I don't have that information handy. There is a lengthy report from the commission, and it might shed some light on that specifically, but in any case, I don't have any specific examples to offer at this time.
Thank you very much, Madam Chairman. Yeah, I mean, I would say the larger reason why you're unable to provide that information is because it's just simply not true. I mean, the fact of the matter is there are people that have experienced great um, uh, disparities in the way they've been treated, either unfairly or truly graced in their lives, of all different backgrounds. Either by virtue of being born into a wealthy family or a impoverished family, but that does not fall across any specific racial or gender lines or based on living in a rural area. I can understand that the way that this bill was written was to try and paint a picture that somehow the data that we might be able to craft regarding the experience of Americans based on these categories might be disparate. But as I mentioned, we can't write laws based on the disparate treatment of even a majority of people in certain groups, because you cannot say with any certainty that it applies to all the members of those groups. There are certainly very successful and wealthy people in all of these categories, and many of them worked very hard to achieve that on their own, and others may have been born into wealth because of their families. But the fact that we are dividing people up into these categories and suggesting that by virtue of being in one of these categories, you have had some sort of life experience which separates you from the rest of the human race, I think is discrimination on its face. You know, one of the things that drove me into politics and one of the things that still drives me is that I love this country dearly. And our founding principles, which are beautiful, have still not been realized. And in 1776, they were much more of a dream than they are today. We could be so close to realizing the words in the Declaration that Jefferson wrote so eloquently, by recognizing that all men are created equal, endowed by their creator with certain inalienable rights, and among them are life, liberty, and the pursuit of happiness. And there's no distinction between peoples based on their race or gender or other superficial characteristics. Now, obviously, slavery existed during that period, and this country went through unbelievable hell to end the practice of slavery, which was wrong and horrific. The very first time it was put into practice in this nation, in the English colonies before it, and around the world. The fact of the matter is, though, we did go through that process, and that certainly didn't solve the problem of discrimination, and it still continues today in some shapes, and people are not always treated fairly. But that goes across many, many, many boundaries. And there's no one specific group of people that can say without a shadow of a doubt that all persons in that group are subject to disparate treatment, or that that other groups are not. And that's kind of what I'm driving at here, which is that, you know, maybe I just simply put it as, you know, at this point, we have done a great deal to make our laws so that they do apply equally. And we've worked hard to outlaw disparate treatment in our laws. And if there still remains inequities in our society, I would say many of them are a direct result of government involvement. And I can point to the way government policies create dependency and impoverish segments of the population as my concern about the way people are treated unfairly, or what I would describe as structural racism. But the bottom line is you cannot suggest that all the members of these groups were underserved or denied fair, just, or impartial treatment, because it's just not true. And I really would like someone to be able to come to me and provide some proof about how it applies to every person in every group and why we should treat the folks that fall into these categories differently than people that do not. I also have looked through this, and I think I'm trying to think of another category, categories that are not included, and those are clearly limited. The next section is a definition about implicit bias, which they have defined in the bill as an attitude or internalized stereotype that affects a person's perceptions, actions, and decisions in an unconscious manner and often contributes to unequal treatment of a person based on the factors of race, ethnicity, gender identity, and so on. I don't doubt that implicit bias exists, but this bill tends to imply that implicit bias only works in one direction, and that only serves to disenfranchise people in the groups that are mentioned. And I don't believe that is accurate also. The next section just defines underserved community. Again, I'm going through this because I just want you folks to think about the fact that, you know, our laws are not for communities. We don't write laws that way. Our laws have got to apply to all people equally. That's part of our fabric, which is that we don't put people into groups. We try and treat all people equally, and that everyone should have the same opportunity in our country, and they should have the same treatment under our laws. And they shouldn't be given adverse or special treatment based on any of these superficial characteristics. But they define underserved community as populations sharing a particular characteristic and geographical communities that have been systemically denied a full opportunity to participate in aspects of economic, social, and civic life, and go through the same list of individuals. But there are lots of people that have been denied a full opportunity to participate in aspects of economic, social, and civic life because they were born in a poor neighborhood. But that has very little to do with their race. The meat of the bill begins on page 3 on line 51, where we establish the DEI division, which will be administered by a full-time salaried director who shall be subject to the supervision and direction of the department head or constitutional officer. Just want to talk about something here that's kind of like off topic, but I think very, very important for people to recognize, because, you know, what I see in this bill is that this bill is nothing more than a way to create some high-paying jobs for some particularly woke progressive government officials at great cost to the taxpayers. In fact, that article that I mentioned points out that in our college university system in the state of Connecticut, they have 34 full-time and 37 part-time employees working in as DEI staff to the tune of $4.2 million, which I think is tremendously ironic, because I know I don't serve on appropriations anymore, thank heavens. I did my time there. But the fact of the matter is that I know that this same college university system is before the appropriations committee regularly talking about how they need funding, that they are short on funding, that they need money to continue their operations. Well, here's $4.2 million. This article points out that this Southern Connecticut State University spends $809,366 in 2023 on DEI staff. Eastern, $530,000. And UConn, $537,207 in salary costs. Not to mention that the commission that is sending us this bill, they're also funded to the tune of $291,714. These folks are claiming to be focused on adding to the diversity and equity of our state, but I don't think that they're adding to the diversity and equity of thought and ideas. I doubt any one of these people could I be identified as a Republican. And really, that's what is important. The diversity of our ideas, the diversity of our stereotypes and skin color, as I said, is something for small people to quabble over. And to be putting it into our laws is going backwards. I encourage my colleagues to actually go back and read the civil rights legislation that's been passed over time, because I think that what they'd recognize that what we're doing here is the exact antithesis of that civil rights legislation. That civil rights legislation was all geared toward the same thing, which was to judge people based on their character and their capabilities and on merit, and to discourage disparate treatment based on superficial qualities. These DEI policies are all about treating people differently based on superficial qualities. And we're paying people mountains of money to do so. So let's talk about what these DEI directors are going to be responsible for. Line 61 says they'll be responsible for all equity-related matters within the department. Can I ask what an equity-related matter might be, Madam Chairman?
I think you would want to go back and look at the definition of equity, and it would relate to anything mentioned in that definition. Fair, just, and impartial treatment of all individuals, including individuals who belong to underserved communities.
Thank you, Madam Chairman. I appreciate that. It goes on to say in small letter C that the director shall be responsible for coordinating the department's equity initiatives, serving as a subject matter expert. Interesting, they'll be charged with producing something called an equity plan, which we'll find out about momentarily, evaluating the policies, including the training and hiring practices of the department, evaluating outcomes of services provided by the department, collecting and using data from the department relevant to the division, supporting the department in creating and sustaining inclusive cultures and behaviors. Madam Chairman, how would that work? How could the director be responsible for supporting the department in creating and sustaining inclusive cultures and behaviors? And can you describe for me what that means?
I believe that the intent here is to ensure that and I think when it's referenced culture, they mean there are cultures within workplaces that can be embracing and inclusive, meaning that everyone's positions taken into account, everyone is heard and paid attention to, and there are other cultures where people are very divided or some people are very left out. And I think the idea here is to make sure that we're also recognizing what has now become known as a culture of a given work site, given workplace.
Well, I can appreciate that, Madam Chairman. I'm just trying to get my head around all of these responsibilities. I mean, we already found out they're going to collect data, and apparently they can collect any kind of data they want. It says including but not limited to, much like the other section that you referenced. And I don't know what the data collection is for. And I also don't know how to define some of these terms. I mean, what would be considered an inclusive culture and behavior versus a non-inclusive culture and behavior? I'm just curious what that means.
I think it is a broad term that will allow the diversity directors to really gain information from people about whether or not they think it's a hostile workplace or it's a workplace that's hostile based on some of the equity criteria that we've outlined in the bill, particularly.
Well, thank you, Madam Chairman. I mean, I appreciate your response and you're doing the best you can to try and answer my questions. And I know that these are difficult questions because these are broad terms. And I don't think that they're very clearly laid out. Would it be safe to say that, that the intent of this bill is by suggesting that they are charged with and responsible for supporting the department in creating and sustaining inclusive cultures and behaviors, that they are going to be determining the makeup of the various departments that they are employed as directors over, to make sure that they appear diverse culturally based on the definition of equity?
I think that the intent is to make sure that every department that's listed here has an individual whose job it is, whose purpose and job it is to really examine relationships in the workplace, gather the data such that it is as it exists, to bring together both data and anecdotal observations to try and make sure that our workplaces throughout the state, and it's a huge state, and there are a lot of workers in a lot of different working circumstances, to make sure that we're intentional and have somebody whose job it is to make sure that we're doing everything we can to have a very fair and just work site for every worker.
Well, thank you, Madam Chairman. I find it ironic that you're suggesting that we should be granting this person who is going to have so much influence over the workplace and the determination of how it appears and what the results are, that they would be granted such broad authority based on anecdotal evidence and their own judgment, when almost every bill we have here is telling people in the private sector that they've got to jump through 1,000 hoops and fill out forms, etc.
Can I
And I-
just, I think I
Well-
want to stand corrected that anecdotal is probably the wrong way to frame it. And I'm not sure, it's not what I intended to say. What I meant, and maybe I'm struggling to find the right word, is that there are observations you can make in a workplace by having someone whose responsibility is to examine relationships in the workplace and both look at relationships as well and look at the conduct and what's happening in that workplace in addition to the data behind it. So you're not strictly looking at data, but you're also looking at the actual reality of that workplace. And it is a huge job. And I think it is, it's a difficult job to do. So I recognize that we're very ambitious in trying to make these changes.
I appreciate the insight, Madam Chairman. I think that the conversation we're having has very little to do with what the words in the bill actually say. And that's the part that I'm concerned about more than anything, because this doesn't say anything about fair and just. It says inclusive. And that means that there is an attempt here to create an environment based on other criteria. And I'm just trying to understand what that is. I would prefer that it simply said fair and just and impartial, but it doesn't say that. If that's our actual goal, that we want to be fair and just and impartial and judge people based on their experience, their skill set, and their ability to add to a particular position, and that might include life experience, the ability to speak a foreign language, etc. I'm not denying any of those things. But what I am suggesting is that that should be the criteria that we are determining how we are going to hire our state's workforce, not on some notion of what is diverse or inclusive because the individuals involved all have superficial characteristics. As I pointed out, that's discrimination. Let's just move on from there. I think it's section little d of section 1, where it says prior to implementing any proposed department policy or adopting any proposed regulation. I mean, now we're talking about a lot of stuff here. This is like everything the department does, every decision the commissioner makes in accordance with the provisions of Chapter 54 of the General Statutes. The department head or constitutional officer shall, not may, shall consult with the DEI director to ensure that the proposed policy or regulation will not have an indirect or direct adverse impact on any underserved communities. And again, Madam Chairman, it does not say to make sure that the proposed policy or regulation will be fair and impartial. It says to determine whether it will have an indirect or direct adverse impact on any underserved communities. That to me implies that it could be very unfair and very partial, as long as it doesn't result in a indirect or direct adverse impact. But this is broad power that we are going to be granting folks who will now effectively, the way I see it, they will be co-commissioners. That's what it's going to be. So the governor's going to appoint commissioners to our various state agencies, presumably based on their expertise in particular areas. But they're going to be filtered in their actions and activities through the lens of DEI. A lens, like I said, which only a very small portion of society, I think, agrees with. And I look forward to being argued on that point, because I think if we start asking people on the street the very straight up question whether or not we should judge people based on merit or superficial qualities, I bet you I win that conversation every time. Section number 2. This says that the director, the co-commissioner for each department, shall create an equity action plan for such department that identifies specific diversity, equity, and inclusion goals. Madam Chairman, can you tell me what one of those goals might be?
I think the goals are to make sure that we are intentional in every department, in every action that we take, whether it's hiring, whether it's promotional opportunities, or whether it's how we serve the public, that we are intentional about making sure that our workforce and the way we're conducting the work really reflect the population of our state, which is quite diverse, and that we mirror the diversity, that we truly represent the people of the state of Connecticut.
Thank you very much, Madam Chairman. So you're suggesting that this section means that they will be creating an equity plan that intentionally requires the mirroring of the state's population in the makeup of the people that are employed in the state agency?
I didn't say the makeup, I said in the work of it. That could be, in fact, the way we address the public. It could be, I believe that the equity plans or action plans are supposed to be broad in nature and make sure that we are conscious of what the way we do the work, who we hire, who we promote, and the way we do the work, the impact it has on our communities, and that we want it to be representative of the people that live in the state of Connecticut.
Well, I appreciate you saying that, but again, you said who we hire, and that's what this bill is all about. It's about who we are hiring. This bill is all about hiring practices. And you're suggesting that we are going to be intentional about who we hire to either mirror the state or to make it quote unquote inclusive. And I'm trying to wrap my head around that. Does that mean that that overrides the necessity of having qualified personnel?
I don't think there's anything that says in this proposed legislation that would override qualifications.
Thank you, Madam Chairman. But wouldn't that, based on this conversation, mean that you would have failed to reach your equity goal if you prioritized the meritorious hiring of people over the desire for inclusion?
I think if a person is qualified, it's always going to be required that the person is qualified for the job that we're trying to fill or for the promotional opportunity that exists. So I don't think that we would ever be suggesting that a person that is not qualified or be promoted or hired. And I don't think there's anything in this proposed legislation that suggests that. I don't think there's anything that directs the department directors to create equity action plans that would include the need to hire people or promote people that are not qualified.
I appreciate that, Madam Chairman. and Thank you very much, because that's a relief to know that we're simply not going to be hiring people based on superficial qualifications and replacing people that are qualified. But does it mean that we might not choose the most qualified person for the job based on an equity goal that is required after October 1st, 2026 to be created by the director as part of an equity action plan?
I think there are aspects of this bill that address hiring, also that address training. There are a lot of ways for us to approach the goal of having a more equitable state work, treating state employees more equitably and creating a more equitable workplace for state employees. There's a lot of different components of it that are addressed in this bill. I think that also we're all very much aware that for many, if not the overwhelming majority of employees within the state, there are collective bargaining agreements that address the issue of hiring and promotions, and that they do have very specific terms with regard to how an employee is selected for a job or for a promotion.
Thank you, Madam Chairman. Going further, it says, that parts of the equity action plan will include identifying the progress made. And for me, that means that they're going to have to provide a report of how much equity they have advanced. And for me, that means that they are going to have to provide a report that shows how they've changed the makeup of each one of these state agencies. And I presume that's going to be measured based on the definition of equity, which is the different categories of underserved communities identified, both in the definition of equity and the definition of underserved community. It's funny, every time we have one of these conversations, I mean, you end up going in a giant circle. I mean, the debate over affirmative action, the same thing has occurred for decades about whether or not affirmative action means quotas or not, and it certainly does. There's no other way to make a distinction about whether or not you're advancing a particular population of people based on superficial characteristics, unless you're counting them. I mean, that's just what's happening, and that's what's happening here. I want to get to the hiring panels, which is coming up momentarily, and that is even more explicit about the desire to put aside the meritorious efforts of individual citizens, regardless of what they look like or where they grew up in a rural area or not, and say, hey, this person is an excellent fit for this job based on their skill set, their knowledge, their life experience, and so on, which should be the only things factored in. And I'll keep going back to that, and I will never apologize for it, Madam Chairman. If people want to come after me because I say that it's better to be colorblind, then let them come. Because that's the only truly moral way to treat other human beings. Since we cannot see into anyone's soul, we cannot understand anyone else's life experience, and we should not assume anything about other people. That's prejudice. In lines 116 through 123, just continuing on in that same section, identify how the department intends to engage with underserved communities, again, in order to advance equity. I won't keep asking the same questions, so Madam Chairman, I know they're difficult questions, but I will leave these questions hanging out there for the people listening to decide what you think it means. What do you think the people that drafted this bill meant by that? Identify training programs. Here we go. I evaluate the applicant data required and identify demographic hiring trends within the department. I mean, am I crazy to think that that's quotas on its face? That is saying we're going to figure out how many people were hired of all of these different groups. So we know what we have to do to create a more diverse workplace. I mean, it's in the title of DEI, diversity. Okay. And I'm not against diversity. What I am against is diversity for the sake of diversity at the expense of any particular individual's rights or providing preferential treatment to any person, regardless of their circumstances, over another person when they actually deserve the job based on merit. And again, I think I would take that challenge to any individual in any community. And yeah, I know that there are people that buy into this stuff, but I think that it's a very small population, and most of them exist in government in the Democratic Party, not in the real world. On section number 3, each department shall collect and maintain data regarding demographic information for each individual that applies for positions with such department. Each division shall annually examine data regarding demographic information for individuals who apply for positions. What is the reason to collect this data about people's superficial characteristics, Madam Chairman?
I think collecting the data will inform us on hiring practices and hiring trends, as has been stated. And we want to look and make sure that our hiring practices are fair and just, and there are concrete things that people can do to help accomplish that. And I think that's what's outlined in the bill.
Thank you, Madam Chairman. Imagine you're me for a second here, and you come to this building every day to debate policy, and you go to the housing committee, and over there, they're telling people that are property owners that they cannot know characteristics about tenants that actually matter, like whether they have a violent criminal past, whether they're on the sex offender registry. Okay? You can't know that in the private sector because you might discriminate against people, even if it's for a legitimate reason, like the public safety or the safety of yourself and your other tenants. But here, it's okay for the government to go ahead and collect data about what your skin color is and what your gender is, and whether you're a Native American or whether you live in a rural area, for the purpose of discriminating for or against you. The irony is insane. It is all about expanding the government power to make society in somebody's image, the people in power. It's not about making sure that people are protected and that their rights are protected, which is what we are charged with when we swear our oath of office. It also collects, they will all also be charged with collecting the data about how far people in each category progressed in the interview process. All right, so let's talk about hiring panels. Section 4, line 145. Each department shall utilize diverse hiring panels to conduct interviews for open positions with such department. Madam Chairman, what is a diverse hiring panel?
I believe that the purpose of this is to ensure that the people involved in doing the interviews have diversity of race, ethnicity, gender, identity, and those types of, those characteristics that you object to. So.
Thank you, Madam Chairman. I don't object to people having characteristics. I just object to using superficial characteristics that do not determine the quality of a human being as the means for any decision-making, particularly the hiring in state government. That's what I object to. But that's what this is. This is, we're going to have a diverse hiring panel. So how do you come up with a diverse hiring panel? I asked the room rhetorically. Without being able to determine who goes on it based on these superficial characteristics. How do you do it without discriminating is the question. I'm going to build a diverse hiring panel. How do I do that without discriminating against or for certain people based on race, gender, age, sexual orientation, et cetera, et cetera, et cetera? How do I do that, Madam Chairman?
I believe that there's some general flexibility given here to utilize employees from other departments if necessary. And, you know, I mean, I know I'm trying to answer your questions directly, but I do think that there has been a lot of evidence and studies that I've seen in the past that people tend to hire people that look like them based on the wrong criteria. And I think that's what we're really trying to get at. If you have a diverse panel for the hiring, that you would avoid that occurrence, which has been documented in many different studies.
Well, thank you, Madam Chairman. I'm glad that you brought up this point, you know, because I want to just address this situation head on, which is this idea that somehow, unless we have these types of policies in place where we're going to practice reverse discrimination, where we're going to actively engage in racism and discrimination for the purpose of undoing the potential of other racism and discrimination, that's ridiculous on its face, especially when you consider that the courts have already made it very clear you can't do that. We have constitutional law. We have the Civil Rights Act. We've had Supreme Court decisions that say so. And more importantly, they have pointed out that there are ways to do this without discriminating. There is a process called debiasing. Debiasing is the idea of screening the knowledge of the interviewer of certain information. It's kind of the concept of like putting in an application, but it doesn't say the age of the person. It doesn't say the race of the person. It doesn't even tell you the name of the person. It just is blind to those issues and only provides the characteristics that are meritorious towards the job that is the position is being sought for. That's a smart way to approach this, because you're actually going to judge people not based on the way they appear, based on those superficial characteristics, but by their skill set and their ability to do the job. But we don't find that anywhere in this document. The whole profession of DEI ignores the fact that there are any potential ways to combat discrimination without using discrimination, because in fact, the goal of DEI is in fact discrimination. I wrote something down earlier and I want to go back to it. I wish I can find it. I know that was a bold statement, but reading this bill, every aspect of the activity that is going to be given to the DEI director tells them to discriminate. It tells them that they have to pay attention at every turn to people's characteristics based on underserved community and equity. I can't repeat enough. Looking at people based on those superficial characteristics is like the most simplistic and childlike way to look at the world. It's not only factually wrong, it's also morally wrong. The creation of these hiring panels, even if they were to result in producing a more diverse workforce, even if they did that in a completely fair and just way, which I know is the focus that the chairman and I think ultimately agree upon, the creation of the hiring panel itself cannot be fair and just. The last section, I think it's the last section. Oh, there's 5 and 6. But 5 has to do with developing a standardized diversity, equity, and inclusion training program. And this program shall be used by the department in completing the DEI training required. And it should be include, but not need be limited to, how to recognize and mitigate unconscious implicit biases. Can I ask, Madam Chairman, how would one mitigate someone's unconscious implicit bias?
I think the training would address it by not only getting us to recognize unconscious bias, but also ways to, as the legislation says, mitigate against it, ways that you can overcome it. Because hopefully the whole purpose of this is that when people identify these unintended biases, that they can find ways to overcome them.
Do you think it's possible, Madam Chairman, that these highly paid, certainly progressive DEI directors that will be hired by the state might have implicit biases?
I assume that we're going to be hiring people who have worked at overcoming any implicit bias that they might have. And certainly are aware of what they have as in terms of implicit bias. I've been through some of these trainings, and I think people who do the trainings are very, are very conscious of their own way of looking at things and trying to address their own biases and always improve themselves. I've found them to be very remarkable people when they're good at their job.
Well, I appreciate that opinion, Madam Chairman, but I follow the news, and I can tell you that, folks involved in the DEI arena end up in the news pretty often. I mean, we are witnessing some things in various parts of the country right now. Not to mention the lawyers involved in the former president's legal battles. The city of Boston. These are just a few of the stories that surround, DEI professionals. And I think it's quite clear that they have extreme, not only implicit, but biases that are quite, obvious that they bring with them every day on the job. And I also presume that people that choose a career in this also have very, very strong political opinions. I don't know how they're going to be mitigating those extremely strong value systems, Madam Chairman, and they're entitled to them. There is no question. But is it beneficial to the state of Connecticut and to the taxpayers who will pay millions of dollars in additional tax money to hire them to affect the policy of the state of Connecticut by using their extreme prejudice that they possess on certain types of political and cultural issues? I don't think so. There's more to the bill, although I think I'll leave it there and kind of wrap up my comments. One thing that I didn't discuss in this, and it's not because I want to go down a rabbit hole too far, but that is the subject of Marxism, which is where this all comes from. The notion of critical theory is effectively this concept that the world is divided into two categories: people who oppress others and people that are oppressed. And Karl Marx wrote extensively about this, and he thought it was the path to enlightenment and a prosperous society, at least in his writings, though in practice, Marxism has only resulted in the ability for authoritarian figures to impress oppress entire populations by depriving them of individual liberty and sovereignty. And for me, it's an incredible threat to our society because our society is the antithesis of Marxism. Our society is based on freedom and opportunity, not on government force redirecting resources, which is what Marxism is about. And this bill is directly about this. I find it offensive to put people into categories and refer to them as underserved communities. I find it offensive. As I started from the outset, there's only one race, the human race. Every one of our life experiences is different. And life is not fair. And sure, some people that look certain ways probably have had more tribulations in their own families and in their pasts. And certainly generationally, that's true, especially in this country. But our goal should be to be overcoming that and reminding ourselves that we're only one race of people, and that's the color of someone's skin or their gender is completely superficial. It doesn't tell you much about their character, their skill set, what kind of person they are, whether they're honest and decent or loyal, because those things transcend all those things. And any person with a double-digit IQ ought to figure that out. People that are still practicing the idea of treating people differently based on those superficial characteristics are small, as I mentioned earlier, and we should be discouraging their advancement in our society. And I look at the entire notion of DEI as that exact thing. It's a way to put people into categories, to diminish them, to suggest that some people are inferior to others, that some people are victims, and that the only mechanism that will help them is some authoritarian figure in government that can fix it for them. That's an absurdity in this country. This country is about freedom and opportunity, and our job is to protect that for every person, to protect their rights to achieve, not to be the decider of who gets what, which is what government has become. There's much more to say on this, but I think I'll leave it there for today. This is not the path we should go down for so many reasons. Again, it's unconstitutional. There will be legal challenges. The Supreme Court has already decided this with the recent decision regarding the affirmative action in universities issue, which was specific, by the way, to government, not necessarily the private sector. And it's wrong, morally wrong, Madam Chairman. I'll be voting no.
Any other comments? Representative Weir.
Very brief comments, and I begin with, as I was reviewing through the list of bills, we had Senate Bill 412, which ironically called into question the issue of quotas. And then right next to it is Senate Bill 414, where we're, in some cases, although it's not calling it out, looking for, calling a positive to quotas and judging based on certain characteristics. So I found it ironic that those two are together and we're arguing different sides of those issues. Furthermore, down on line 189, I'm looking where talking about the department, and this isn't a question. I'm not going to ask any questions. I'm just going to make a statement that one of the things is prioritizing that each department shall require a minimum of 4 hours annual training, and prioritizing providing such training for supervisory employees. And I think that, our many different departments offer great services, but we should be prioritizing service to the Connecticut taxpayer above all else. Should be the service to making this state a great place to work, do business, and allowing our employees to provide the great service to the taxpayer who are funding all this. And I think this legislation and even the the underlying, the undertones are really a disservice to the great employees who work for the state of Connecticut, where we're talking about judging people on one thing or another and not on their work ethic or their ability or their skill or their merit, which many of our state employees provide a tremendous service to the state of Connecticut. So I think we ought to emphasize continuing to provide that great service through many different means and not place emphasis on putting people in boxes. Thank you.
Any other comments? Questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 5, Senate Bill 414, an act concerning equity in state employment. The motion is to JFS the bill to the floor, and the relevant LCO is 3228. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert, Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Madam Chair.
Thank you. We will be holding votes open. The next item on the agenda is House Bill 5469, an act concerning flexible holidays for state employees. It's a JF to the floor.
Seconded.
It's been moved by Representative Wilson, seconded by Representative Hughes. Any comments or questions? Representative Weir.
Thank you, Madam Chair. Going through this, I appreciate the sentiment of the bill. I recognize, I saw some of the testimony. I heard from some proponents for the bill with the looking for the ability to move, looking for a flexible holiday, perhaps due to a religious nature. And I can appreciate that. I'll just give want to talk about how this works in practice in the private sector, because as an employer, we did offer at least one floating holiday, but that generally speaking was for people who were not customer facing. So for instance, if we had somebody who was, we had a contracting business, so perhaps a carpenter who was doing work in the shop, who wasn't dependent, this wasn't somebody answering the phones, wasn't dependent on interacting with a customer at that point in time. We were able to afford that person the flexibility. Okay, I'm going to take this Monday off to observe my holiday, but I can come in and make it up on a Saturday. And I don't see how in this bill, well, let me stop right there. That's the private sector where you have a customer, not an employee who's not customer facing. In a private sector where the employee is customer facing, like a bank, I'm not sure how a bank would be able to say, well, you can take the day off when we're open to observe your holiday, and then you can work a day when we're not open to make it up. I don't see how that would work in practice, and I have a similar issue with the fact that we've painted a broad brush across state employees who, if they're customer facing, I'm not sure how this is going to work out, how possibly a customer facing employee, how this could possibly work. So I think it's not narrow enough. And I know I had a couple notes which I seem to have put aside for a second. Bottom line is I think this is too broad. I appreciate the intent. I don't see why this couldn't be worked out through bargaining, or why this couldn't be worked out administratively through an employee and an employer. But I think for us to weigh in on this and say, just go ahead and do it, when I think we've missed out on working through all the fine details. Good in concept, but I can't support the fact that I think we're going to we will inevitably open up some unintended consequences for those who are, somebody working the counter at the DMV who's going to elect to take a day off to observe a holiday and then make that up on some other day, where they're either not needed or the DMV isn't open. They're not open to customers on a certain day of the week where otherwise they might be able to fit it in. So I'll be a no on that for those reasons. Thank you.
Representative Yakarino.
I'm gonna be very brief. I wasn't gonna speak on this, but in concept, I do like it somewhat, but the problem I have is it says the state employee work and Christmas, for example. Well, pretty much everything's closed on Christmas. So to trade with somebody in that, it's nearly impossible. So I do agree with Representative Weir that this should be worked out with either the bargaining units or the agencies. I put a bill in, I don't know, 5 years ago, or no, 4 years ago, Governor Lamont was just elected. And he loved it for having election day a holiday, but nobody could agree on what they're going to give up for that holiday. So former Secretary of State Merrill didn't like it. Governor Lamont liked it. My point is, through the bargaining units rather, nobody could agree on what day to give up. So to me, that would be important to have that day off for everybody, but obviously, have it a holiday. So with that, I'll continue to listen, but in concept, it sounds nice, but I don't know if practicality is going to work, because most holidays people have off already. You already have those holidays off. So what are you going to, you're not really giving anything up, I don't think. And if, there are Jewish holidays that you have off. Rosh Hashanah, I think people have off. Columbus Day people have off. Of course, Christmas, Thanksgiving, and so on, you have off. Rosh Hashanah doesn't. Yom Kippur then, okay. It's a federal holiday, isn't it? Okay, then I'm wrong. I can admit it when I'm wrong. I can admit when I'm wrong. And I do have a lot of Jewish friends. Maybe they just take it off on their own. I don't know. But my point is that'd probably be the only holiday, and it's a legitimate holiday. But I'll continue to listen. In concept, nice, but I don't know. I think they could do this without. I think it could be done without legislation. That's my view. But who am I to say? Thank you for your indulgence.
So I want to say that I do appreciate that there are proponents of this bill that are really working with DAS and with, with decision makers to see how it could be done. Because I think that flexibility, recognition of people celebrate different holidays and different cultural traditions, I think it's important to recognize that. And I know that problems don't get solved in a workplace unless there are people that are really working very hard to find workable solutions. And I know they're still working on this with DAS. We have not been said this is impossible. I think people are still open to trying to figure out how it will work in the practical ways that have been discussed here. There is a lot of work in our state that is done, can be done anytime, any day, and that doesn't interface with the public. And I think that it's easier to envision how this could work in those situations. But again, I admire the people that are really dedicating themselves to trying to figure it out, because it's not there's not an easy, clear-cut solution, or we would have done it already.
I do agree with you for a second time, is it all right? And it's like when you have a private sector, when you want to have employees trade days off, I think that's a good thing. I think in the public sector, they should be able to do that and hopefully work it out. And, it's like if I was Jewish, I'd want to take those holidays off. A lot of my friends do. My wife works in Manhattan for a company, Jewish company. That's a holiday for them, so she's off. But other holidays she doesn't have. So maybe I'll continue to listen, but I'm rambling a little right now. I think it's interesting because I think if you could trade in your department, DAS, or whatever, you should be able to do that now. And, swap days. Thank you.
Thank you. Senator Sampson.
Thank you, Madam Chairman. Yeah, I'll just follow up with my comments, very similar to my colleagues. The question I have is really, why can't this just happen through the administration? It seems to me that this should be the kind of thing that gets worked out by any particular state agency. I'm going to support it today because I think that in the end, the language will get worked out by the parties. And, I don't have an objection to it. I mean, the state government can run the state government whichever way they choose. And if it's okay with the the commissioners and the various state agencies to allow their employees to engage in this activity, and there was no testimony in opposition that I saw. I don't have an objection to it. Again, I don't know why we need to make a law for that, but I'm happy to support it today.
Thank you. Any other comments or questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 6. House Bill 5469, an act concerning flexible holidays for state employees. The motion is to JF the bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is yes.
Representative Weir,
No.
Representative Ackert, Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes.
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes yes.
Thank you, Madam Chair.
Thank you, and we will be holding votes open. The next item on the agenda is item number 7, it's House Bill number 5470, an act concerning rideshare and delivery driver minimum standards. It's the JFS to the floor, LCO number 3345. So moved.
Second.
It's been moved by Representative Hughes and seconded by Representative Wilson. Any comments or questions? Representative Weir.
Thank you very much, Madam Chair. I obviously recall listening to the testimony on this. There were lots of proponents who came out for the bill, several of whom were drivers, talking about the concerns about lack of transparency, lack of visibility to the billing, lack of flexibility. And several of them, more than one, appealed to say, look, we're not getting paid enough. And we're not getting paid enough and we don't have visibility of what the companies are making. And so took that into consideration. The other thing we heard was the fact that there was a lack of reciprocity between Connecticut and surrounding states. So for instance, as I understand it, a New York driver could pick up a New York rideshare driver could pick up a fare in New York and drive that person to Connecticut. But a Connecticut driver could not could take a Connecticut passenger from Connecticut to New York, but then couldn't turn around and pick up a passenger, pardon me, and bring him back. And so on one hand, you had the drivers who were making a one-leg trip, not able to get paid for the ride back, or you had drivers who maybe aren't able to do it through the app, and talk about those bad apples who were putting, thank you very much for that, who would then pick up a passenger outside of the app, and there was very little oversight, and you had a consumer protection issue potentially for the passenger. So that part of the bill, the reciprocity, I think this bill goes a long way to do it. But the first part of the bill, where the drivers were asking for more money, transparency, visibility, flexibility, I don't think this bill as it's written is going to do that. So I would like to offer an amendment to this bill. And if you allow me to explain, I just have a verbal amendment to offer for today.
Proceed.
So our proposal is to strike sections 1 through 4, which talks about all the encumbrances to the rideshare services. We don't believe that any of that language in sections 1 through 4 is going to do anything to provide the drivers with more money, transparency, visibility. Not going to help them out at all. And I think a lot of the stuff that it's offering to do, the customers don't necessarily care about. So we'd like to simplify this, really focus on section 5, which is the reciprocity, which we believe will will help the drivers in the ability, it will encourage Connecticut to engage with New York and whichever other surrounding states to try to fix that problem so that the drivers will have the ability to, through the app, get paid for their services. And we believe that this will allow for better consumer protection for the people, passengers in those vehicles. So that is our intent. Strike sections 1 through 4, keep sections 1 through 5, and also authorize LCO to make any conforming and technical changes. I move adoption. And a roll call vote, please.
Give us 1 minute. The amendment's been moved and seconded. I'd ask for a short recess. So I believe I think we're dealing with the same LCO because of the sections that you struck, that you proposed to strike. But you did make reference in your remarks to wages being in this bill, and we had removed that in the S language. So I just want to make sure that there wasn't a misunderstanding about that. Okay. So any other comments or questions on the amendment? Senator Sampson.
Thank you, Madam Chairman. I just want to say that I support the amendment. I think the bill is much improved in this LCO that is before us. I think the more controversial elements were taken out already. And I concur with Representative Weir that I think what's left here, the thing that's really of value is the part that would encourage the state of Connecticut to negotiate terms to allow interstate arrangements. And if we want to see something that is beneficial to this industry and the drivers themselves, I think that's the most important piece. And if we simplify this bill to that, I think that you might have an opportunity to get it to fly through, both chambers. And that's why I would encourage adoption.
Thank you, Senator Sampson, and I appreciate your remarks and those of Representative Weir and the support for a practice that we've, I think, all heard from the drivers is really damaging to the drivers here in the state of Connecticut. And so I appreciate your support for that. I would, however, say that I really think that it's critically important that drivers know that there's transparency about what's being charged and what they're receiving for every ride. And that's what we retained in this. We did take out the more controversial issue around wages. And I think we did that with the hope that we would be able to pass this bill this year. And so I would urge that people go back and look again about the transparency issue. I think it is something that workers are entitled to. Anybody's entitled to know, what are people being charged and how much are they getting for each ride? Because there's been representations that really made by the app platform owners that I think it's really hard to verify how much people are getting when we have no idea. So this would help, I think, all of us have a better understanding of the economics of being one of these network transportation drivers. So with that in mind, I would just urge my colleagues to vote down this amendment and vote for the underlying bill. Any other comments? Representative Acker.
Thank you. Thank you, Madam Chair, and I appreciate the opportunity. I do support the amendment. The area that I have paused, and really I think the only area that I have paused is when we talk about receipts, and I do You know, I think a person working should know how they're being compensated 100%. Agree with that. I don't believe the individual paying the bill should have preview to what a driver's getting paid. Like what, how, are they, you know, what are they receiving? I think that's kind of that individual's. I'm not allowed to share worker, my employees, pay with any other person. That's their own, that's their personal information. So that's where I have pause. That's why I supported the amendment. And look forward to having further dialogue on this legislation as as it moves forward. Thank you, Madam Chair.
Thank you. Senator Sampson. Okay, seeing no other hands, I would ask the clerk to call the vote on the amendment.
A roll call vote has been requested on Amendment A to House Bill 5470, an act concerning rideshare and delivery driver minimum standards. This is a vote on the amendment. Senator Kushner,
Senator Kushner votes no.
Representative Sanchez,
Representative Sanchez votes no.
Senator Cabrera, Representative Wilson,
Representative Wilson votes no.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Ackert,
Ackert is yes.
Representative Belton,
Belton votes no.
Representative Hall, Representative Hughes,
Hughes votes no.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes yes.
Thank you, Madam Chair.
Will the clerk please announce the tally?
The tally of the vote is 4 in favor, 5 nay, 0 abstentions.
The amendment fails. So now back to the underlying bill. I believe Senator Sampson, you wanted to comment? Oh, I'm sorry. I forgot. It's been a while.
Thank you. Thank you for that. I gotta say, I'm disappointed in the route that, you know, that amendment didn't pass. And I'll tell you why, is I think, you know, that was an opportunity to go to both chambers with a, you know, strong showing of support for a smaller piece of the bill, the legislation that everybody agreed made sense. And, you know, here we have several unanswered questions in the bill. I think, again, what the drivers were most asking for, those parts have already been removed from the piece of legislation in this JFS language. So I think that, you know, the most impactful piece of that is Section 5, and the fact that you know, that we have differences on sections 1 through 4, I think is disappointing. So I just made some couple really brief notes, and I want to just hone in on, you talked about that the drivers were interested in more transparency. And Madam Chair, if you can point out to me in this bill what information the drivers are going to glean from this bill that they don't have already.
I don't believe the drivers have information from the employer, from the transportation network company, as to how much the total fare was that was paid. And they don't have it itemized to know if any, you know, to understand completely how that fare is being allocated in terms of what goes to the driver and what goes to the company. I know there's been some conversation in testimony in past years about costs for the company. An itemized receipt would also show some of those costs that the company has.
Some of the, I misunderstood, would show some of the costs that the company has?
It could, in fact, if there was a part of it that was designated for some other fee that the company had to pay out of that fare.
Okay, so if the rideshare driver knows what that total charge is, how is it the opinion of this, you know, or how is it your opinion, or can you explain to me how that will translate into more dollars in the driver's pocket just by knowing what the total fare was?
I don't think it translates into more dollars. I think it translates into an understanding of how much the driver is actually being paid of the fare. So that the things that have been asked for is the destination of the prearranged rides, the total time and distance. I think that then you begin to see how it breaks down in terms of what the actual earning is for that driver, both in terms of how many miles they put on and also how much time they have put in.
Okay, thank you. If I just compare, well, first of all, I'm gonna come back. I'd like to compare this to just about any other industry. I mean, if you go to the restaurant and you get a bill, I guess the server can see the total, the total bill to the customer, but they're not getting, they're not having visibility to the cost to the employer. And I'm just trying to figure out how this is going to put more money, because that's what we heard was we're not making enough money. How is this going to translate to more money in the pocket of the driver?
There's no question that the drivers would like us to pass a bill that guarantees more money, that gives them some stability in their income as opposed to the variable income that they're earning now that they don't always understand. The transparency issue is just to help better understand, demonstrate, and document what people are being paid. I don't believe it does result automatically in greater income.
Okay. And I think the other important distinction to make is that, these are subcontractors. These are not employees. These are third-party contractors. So if I hire a plumber at my house, who would be a subcontractor, and that plumber gives me a bill for $1,000 for installing a sink or $500 for fixing a toilet, we don't require their employees to see the bill. Or if I guess better yet, if I hire a general contractor to put an addition on my house, this is probably more accurate, and he hires a plumber, and the plumber charges $500 and the GC charges me $1,000. If I'm happy with the job, I don't believe at any point in the transaction does the plumber say, geez, I want to see what the GC charged the customer. And so that is why just one of the several issues I have with this is, if the drivers don't feel if the plumber didn't feel he or she was getting enough money, that's on them to increase and charge more. And in this case, it seems to me that the drivers have the option to petition the ride share or not take the job. And if there's a movement not to take the job, then, the ride sharers, they need drivers, they're going to act accordingly. So I think by us inputting ourselves here, creating more burden for the company to do business, to share information on pricing, which also, we heard testimony, I don't believe it was this year, but that's proprietary information. Now, that driver, there's a couple major rideshare industry companies that we're aware of, and now one shares the charges with the other. So I have an issue with that piece of the bill, and cannot support it. Thank you.
I do want to point out that customers do have access to know how much they're going to be charged for a ride and have the opportunity to say, oh, I would rather go with other company because they're going to charge a lesser amount for the ride. This really doesn't go to what the consumer's choice is. I do think that I used to take taxi cabs a lot when I lived in New York City. And on those receipts that I knew how much I was paying based on the time and distance of each trip. So I know the information is available and it is built into this. The question is, what is the problem with sharing that information with the driver? And these companies are already, we know, charge different rates at different times of day. It's part of the algorithm. It's part of their business model. And so I think it's very hard for a driver to have any sense of what they're going to make on a given ride, given fare that they take. So I think that transparency will help the drivers to have a much better, clearer understanding. And it might lead them to say they're going to work for one company versus another, because they would then be able to gauge and recognize that, one company pays better than the other. Right now, it's very hard for them to tell anything.
I would just like to just follow up and respond to that. I mean, today, they know what they're getting paid. They see the pay. So if we're driving for company number one versus company number two, and, one is paying better than two, today they know what they're going to get paid. But I would also just add that experientially, I've had the opportunity to attend events out of town, out of state, have taken these rideshare, and in talking with the drivers, the rideshare companies may be charging more based on events or peak times, but the drivers were getting paid more, which is why some of them chose to work at these hours of the night and be available at 10 or 11 after an event. One, because there was more money. Two, because there were lots of opportunities, so they could get in and make several trips after a sporting event or a concert. So it is my understanding that not only do the rideshare companies charge a additional fee or surge pricing, I think they call it, but that the drivers are taking part in that as well. That's my understanding. And I'll follow up with, this is not the only industry that does this. For anybody who's tried to book a flight around spring break or another popular time of the year, it happens with the airlines where there are additional costs based on demand. There are restaurants who charge cover charges, and bars that charge cover charges for busy times of the week. So I'll just leave it there that this is, we're honing in on one industry, but this occurs plenty of time in the marketplace. Thank you.
Senator Sampson.
Thank you, Madam Chairman. I just want to echo the comments of my colleagues, particularly Representative Ware, who very eloquently pointed out that, the minority does matter. The fact of the matter is there is an opportunity to amend this bill to something that might have left this committee unanimously and had the opportunity to be passed by both chambers without much debate or disagreement. But as it stands, now the bill is probably going to leave here with several no votes, and there'll be an indication that there's going to be a debate in both chambers. And I'm annoyed. I'll add that to the conversation, and I'm likely to engage in lengthy debate on the floor of the Senate as a result, because we've taken what could have been a good bill that we worked on together, which is what I said just a couple of days ago, the people of Connecticut have asked us to do. And instead, we've turned something into a partisan discussion and debate because the majority feels that they have the power to force through any piece of legislation that they can. And I'm just going to remind my colleagues that you don't have that power. You can have the votes, not the power. The people have that power. And at some point, they're going to wake up and they're going to say, look, these folks are trying to do far too much to change our society in ways that we don't agree with. And they're going to push back on that. And in my small way, I represent that faction of people in the state of Connecticut. And I'm going to speak up on their behalf in this particular case. The issue here with the particular bill is that the final section of the bill is something that would actually benefit people without doing any harm whatsoever. Something that we'd all should just get behind and do as a matter of course. Whereas the sections that the majority voted down removing are impediments to commerce. They are unnecessary mandates on private industry and independent contractors that neither party, I'm aware, has in any large numbers asked for. There's already a requirement in law under section 13B-118 about the delivery of a receipt to the rider on behalf of the driver. I presume that the driver has access to that same document. It shows most of the requested information. The information that, not to mention the fact that it's going from a reasonable period of time in current law to not later than 5 minutes. What makes it, the responsibility of the state of Connecticut to just tell these folks that are engaged in their private business arrangement that, one of them has to provide documentation to the other in 5 minutes. If they drivers were concerned about that, they would negotiate that with the network company. Presumably people are accepting the terms of the contracts offered by those transportation network companies because they see them as favorable enough to take that employment and or that contract work, whichever way you want to describe it. But the fact of the matter is that I object to the other sections because these are mandates on private business. They are job killing mandates that might cause this industry to rethink how it operates in Connecticut. It will certainly raise their costs, which will be passed on to consumers or reduce the amount that they can actually compensate the drivers for. It's not to the benefit of the people of Connecticut in any way, shape, or form. And I'll be continuing to debate that at length going forward. The alternative is simple. Let's pass the positive portion of the legislation together and celebrate. Thank you, Madam Chairman.
Thank you. Any
Madam Chair?
Representative
I'll be
Yakarino?
very quick. I wanted to support this legislation because of the fixes, but I have a serious issue. No employee should know what the business person is, what it costs them. That causes a conflict in itself right there. There's gonna always be a dissension. There's always gonna be an issue. They get paid, they should get paid a fair wage, but to me, that's just going down the wrong rabbit hole where I have business. I don't want my employees see what I do, but they don't know what it costs me. At the end of the month, sometimes it's even hard to make it. But if they see thousands of dollars in one day and then you can't pay the bills at the end of the month, there's no good in that. So to me, that's the big issue. There's a lot of work that goes in any business, and God bless all the employees and employers. But when people start seeing, people ask me now, what do you pay for that? It's really nobody's business because they don't know what I'm spending or everything else I'm spending. So to me, that causes dissension. The rest of the bill, I think you've done a good job cleaning it up, but that's the part that's the sticking point for me. Thank you.
Thank you. Any other comments, questions? Seeing no hands, I'd ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 7, House Bill 5470, an act concerning rideshare and delivery driver minimum standards. The motion is to JFS this bill to the floor and the relevant LCO is 3345. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert,
No.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes.
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Madam Chair.
Thank you. We will be holding votes open. Item number 8, Senate Bill 407, an act granting vocational agricultural students access to workers' compensation. Is there a motion?
Second.
It's been moved by Representative Wilson, seconded by Representative Hughes. This is a bill that will insert into the statutes that cover workers' compensation that an employee includes a person who is a vocational agricultural student. And you'll see that in the underlined language. Is a student of a regional agricultural science and technology education center who is enrolled in public work study program as defined and approved by the Commissioner of Education and the Labor Commissioner or a program established pursuant to section 10-20A or an internship as defined in 31-23. Is there any questions or comments? Representative Weir.
Thank you, Madam Chair. I want to point out that I'll just make a brief remark that I'm in favor of what I think the bill's intent is. And I will be a yes today with the hope that, some of the proponents will relook at the language in the bill. And I think it may need some tweaking to achieve what the desired intent was. So the way I read it, it may not exactly be achieving what the intent was, but I'm going to look forward to seeing the proponents look at this and making sure that does meet the intent.
Thank you. Any other comments? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 8, Senate Bill 407, an act granting vocational agricultural students access to workers' compensation. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Acker,
Yes.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes.
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Yakarino's yes.
Thank you, Madam Chair.
Thank you. We will be holding votes open on to the next item, item number 9. House Bill number 5468, an act concerning time to plan for separation from employment. It's a JF to the floor. Is there a motion?
Second.
It's been moved by Representative Wilson and seconded by Representative Hughes. This is a bill that would require an employer to provide advance notice of 12 months prior to making a change in how unused vacation or sick benefits are paid. Paid leave, excuse me, it says paid leave. It's includes but is not limited to compensatory time, vacation time, personal days off, or other paid time off. Any comments or questions? Seeing none, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 9, House Bill 5468, an act concerning time to plan for separation from employment. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Yes.
Representative Acker,
Yes.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes.
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Yes.
Thank you, Madam Chair.
We will be holding votes open. Item number 10, House Bill 5271, an act increasing the unemployment compensation threshold for agricultural employers, and this is a JF to the floor. Is there a motion? It was moved by Representative Acker, then seconded by Representative Wilson. This is a bill that will raise the threshold for consideration of an agricultural employee to be deemed, the employer to be deemed require payment into the unemployment trust fund from a current 20, which is currently, thought I had it underlined. Hold on a sec, I want to make sure I say it right. The bill increases from 20,000 to 25,000, the compensation threshold that determines whether an agricultural employer and its employees are covered by the state unemployment law. Any comments or questions? Seeing none, I would ask that the clerk call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 10, House Bill 5271, an act increasing the unemployment compensation threshold for agricultural employers. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Acker,
Yes.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes.
Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes yes.
Thank you, Madam Chair.
Thank you. We will be holding votes open. The next item on the agenda is item number 11, I believe. 11, Senate Bill number 410, an act concerning paid internships for high school students. Is there a motion?
Second.
It was moved by Representative Wilson and seconded by Representative Hughes. And this is a bill that would allow 14 and 15-year-olds who are engaged in a course of study to be engaged in employment. I do want to point out that the JFS language requires the employer to pay the full minimum wage. So it exempts those employees from the section of our minimum wage standards that would otherwise provide for 85% payment of the minimum wage. And I will point out that this was done at the request of the proponents of the bill. Any comments or questions? Yes.
Just I skimmed through the substitute bill. Didn't that remove the full minimum wage and put it down to 85%? Or am I misunderstanding that?
No, it's the opposite. It wasn't written, the reason we had to do substitute language after we had originally done substitute language is because we had not made it clear that it was to remove it from the part of the statute that provides for workers under 18 to earn 85% of the minimum wage for a period of 90 days. And if you'd like, we can get LCO to comment on that, but it was just to make sure that it was clear that was the desire, that was the request we got from the proponent, and there was agreement on that.
Okay, no, then good to go.
Okay. Any other comments or questions? Seeing no hands, then I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 11, Senate Bill 410, an act concerning paid internships for high school students. The motion is to JFS the bill to the floor. The relevant LCO is 3385. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Ackert,
Yes.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes yes.
Thank you, Madam Chair.
We will be holding votes open. We're going to hold votes open until 6 p.m. just to ensure that everyone has an opportunity to vote. I do want to take the time to thank the members of the committee who, this will be our last meeting for this session. What's that? Oh, my goodness. Senator Kelly's going to kill me. I got ahead of myself again. I apologize. I was ready to make all the nice comments about everybody. I apologize to Senator Kelly, so I hope you will communicate that. We do have one more item on the agenda, and that is Senate Bill number 329, an act concerning hybrid or telework work schedules. Is there a motion? It's been moved by Representative Wilson and seconded by Representative Hughes. This would require certain agencies of the state, I believe it's DEP and DOT, to develop a marketing campaign that would promote the use of hybrid telework and other flexible work schedules. It lays out that it would include monthly public service announcements posted on DOL's website. And it would explain the impact that flexible work schedules have on emissions, wear and tear on the state's roads, fossil fuel consumption, and traffic congestion. Are there any comments or questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 12, Senate Bill 329, an act concerning hybrid or telework work schedules. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Ackert,
No.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino, no.
Thank you, Madam Chair.
Thank you. And we will be holding votes open, as I said, until 6 p.m. And I do want to now take the opportunity to thank the members of the committee, but, for the time spent together on these pieces of legislation. But I know we all work hard, but the people I think that often are not recognized that work the hardest are the nonpartisan staff and our clerks. And so I do want to thank Heather Reeves, Lee Hansen, and John Moran for the many, many hours they've put in preparing the legislation and putting it into a form that we could debate and vote upon. I also want to thank our clerk, Cameron Clark, who just does an amazing job and keeps us all on track. We really appreciate him. He has had the assistance this session of Noah Gula, did I say that correctly? And Jay Snookus, who is upstairs working on our minutes. And I do want to also mention my aide, Haley Zawolinsky, who, while she is my aide, I know she pitches in whenever we need her help with this committee. So we really appreciate all of the work that you put in. We know that work is not done. It really, in a way, has only begun, as we now will go into sessions where we will consider these bills and vote on many of them. So I appreciate everyone's effort here today. And I want to ask if there are any comments from my co-chair.
I just want to thank everybody on this committee. It has been a pleasure. A lot of familiar faces, a lot of discussions, disagreements, but respectfully, and work to be done. I do want to thank the vice chair, Darrell Wilson. He works so hard,
You're right.
thoroughly to help with all of the bills that you see before us. And more importantly, some dissenting voices on certain things that we disagree on, and we try to find common ground on to get things done, and it's made us better for it. And I do want to give a special shout out to Anna Allen, who is our CEC, is it CEC? Got it right. Who has to deal with both of us every single day. So thank you so much to her for all her efforts. But thank you, everybody.
And I thank you for reminding me about our vice chairs, because Darrell, I too want to thank you for all the work that you put in. And I do want to recognize that George Cabrera, who's the vice chair from the Senate, he has a much more difficult time being engaged when we're in committee meetings, because he is the chair of another committee, and that always makes it tough on senators. But I do appreciate George's support and work on all of these bills, and I hope that things go well for him in his endeavors. I know it's been a rough session, so I would like to ask our ranking members if they'd like to make comments.
Thank you very much, Madam Chairman. Finally, something that we definitely 100% agree about, and that is thanking our staff and our colleagues for all of the hard work that they put in to make sure that we are informed and have the proper information in front of us, and that our committee meetings move as efficiently and effectively as they possibly can. Everybody does a great job on this committee, and I'm very pleased with that. I want to also add just a couple of people, which are the Senate and House counsel. I see Greg Hannon by the door, and Nick Presto, who works for me in the Senate. Both those guys do a lot of hard work, and they keep us prepared so that we can, do our part in the committee as well. So thank you very much, Madam Chairman, for the opportunity to say a few words, and I look forward to our discussions on the Senate floor. I'm sure they will be enjoyable and robust. Yeah, that's a good term for it. And I wish everybody luck for the rest of the session. Thank you.
And I appreciate that you recognize. I saw Greg standing over there too, and I was thinking, oh, I forgot Greg and Nick, and also Molly O'Connor and Chris Calabrese. They all do a great job, and no intentional slight of any of them, because we wouldn't be here without them. Representative Weir.
Yeah, again, I want to echo Nick and Greg for their help and the great attention to detail by Cameron and his staff, and Cameron's variety of music at the early morning that he plays out in the office. It's good stuff, from Smashing Pumpkins to I don't know what else you got, Enya. So thank you.
Thank you. With that, we will be in recess until 6 o'clock. So if folks want to vote, they can vote on Zoom or in the labor room, room 3800. Thank you.
Hello, Senator.
Hello.
Hang on, I don't have audio right now, so just give me one moment. Okay, let's try that again.
Hello.
Okay, I can hear you now.
Great.
So I have your votes on item 1, item 2, item 3. So item 4, Senate Bill 412, an act concerning the protection of warehouse workers, JFS to the floor.
In the affirmative. Senator Lusser.
Agenda item 5, Senate Bill 414, an act concerning, 1 second.
Votes open.
Okay,
The Labor and Public Employees Committee will hold votes open.
apologies. Agenda item 5, Senate Bill 414, an act concerning equity in state employment, JFS to the floor.
In the affirmative.
Agenda item 6, House Bill 5469, an act concerning flexible holidays for state employees, JF to the floor.
In the affirmative.
Agenda item 7, House Bill 5470, an act concerning rideshare and delivery driver minimum standards, JFS to the floor.
In the affirmative.
Agenda item, 1 second on that. There we go. Agenda item 8, Senate Bill 407, an act granting vocational agricultural students access to workers' compensation, JF to the floor.
In the affirmative.
Agenda item 9, House Bill 5468, an act concerning time to plan for separation from employment.
In the affirmative.
Agenda item 10, House Bill 5271, an act increasing the unemployment compensation threshold for agricultural employers.
In the affirmative.
Agenda item 11, Senate Bill 410, an act concerning paid internships for high school students, JFS to the floor.
In the affirmative.
Agenda item 12, Senate Bill 329, an act concerning hybrid or telework schedules, JF to the floor.
In the affirmative.
Thank you, Senator.
Thank you, Cameron. Good to see you.
Good to see you as well.
Hey, Cameron.
Hello, Senator Cabrera, and I see Representative Hall joined as well. I can just get both your votes at the same time here.
Okay.
So agenda item 1, Senate Bill 7, an act concerning Connecticut paid sick days, JFS is the floor. Senator Cabrera,
Senator Cabrera votes yes.
Representative Hall,
Yes.
agenda item 2, Senate Bill 12, an act modernizing the paid sick days statutes, JFS to the floor. Senator Cabrera,
Yes.
Representative Hall,
Yes.
agenda item 3, House Bill 5005, an act studying paid sick days, JFS to the floor. Senator Cabrera,
Yes.
Representative Hall,
Yes.
agenda item 4, Senate Bill 412, an act concerning the protection of warehouse workers in the state, JFS to the floor. Senator Cabrera,
Yes.
Representative Hall,
Yes.
agenda item 5, Senate Bill 414, an act concerning equity in state employment, JFS to the floor. Senator Cabrera,
Yes.
Representative Hall,
Yes.
agenda item 6, House Bill 5469, an act concerning flexible holidays for state employees, JF to the floor. Senator Cabrera,
Yes.
Representative Hall,
Yes.
agenda item 7, House Bill 5470, an act concerning ride share and delivery driver minimum standards, JFS to the floor. Senator Cabrera,
Yes.
Representative Hall,
Yes.
agenda item 8, Senate Bill 407, an act granting vocational agricultural students access to workers' compensation, JF to the floor. Senator Cabrera,
Yes.
Representative Hall.
Yes.
Agenda item 9, House Bill 5468, an act concerning time to plan for separation from employment, Senator Cabrera,
Yes.
Representative Hall.
Yes.
Agenda item 10, House Bill 5271, an act increasing the unemployment compensation threshold for agricultural employers, JF to the floor. Senator Cabrera,
Yes.
Representative Hall.
Yes.
Agenda item 11, Senate Bill 410, an act concerning paid internships for high school students, JFS to the floor. Senator Cabrera,
Yes.
Representative Hall.
Yes.
And agenda item 12, Senate Bill 329, an act concerning hybrid or telework work schedules, JF to the floor. Senator Cabrera,
Yes.
Representative Hall.
Yes.
And thank you very much. That's it.
Take care, guys. Thank you. Thanks.
Thank you.